Good morning, Your Honor. This is Joanne Hennessy. I'm here for the City of Miami Beach for the jail arraignment calendar.
Great, and you are Miss Hennessy. Okay, all right, thank you.
Thank you. Good morning.
Good morning. What do we do next? Misdemeanors? Okay, do we have misdemeanors? They should be coming.
Yeah.
I'm sorry? Okay. Okay, all right, thank you. Thank you, thank you. Who's the misdemeanor clerk? Eric? Oh, Miss Terry? Oh, I can let Miss Terry know that we're ready. You want to let her know? Okay, thank you. I guess we can go off record for a couple minutes until we get the misdemeanor clerk here. It's 10:05, so. Thank you.
Yes, Judge.
Yeah, comfort break. Take a comfort break at this time. Yeah. Okay. What are we doing next now?
Misdemeanors and.
So Judge, for some reason, we did not get a copy of the priors today, neither for us, for yourself, however, we did look at them, and I marked some of them down.
Okay, okay, all right.
That is the copy.
Okay, so we don't have priors for the misdemeanors.
I did list the most recent ones.
Okay, all right.
So I will read them out.
Okay, sure.
Thank you.
Judge, just for the court's information, I do have the priors available on the arrest.
Okay, all right. Good morning, Miss Terry. Hey, how are you? I have the best for misdemeanors. All right, how are you? Good to see you. Miss Terry, how are you? How many pages do we have?
We have 9.
Okay, that's not too bad.
Good, but bond out.
And we have some bond outs. Okay, that's not too bad.
You are. Okay. How you doing? Okay.
Good. You too. Great seeing you. I will let her know.
You know. It's your calendar.
Okay, all right. Do we need to put the bond outs in the record or not?
Yeah.
We do.
And I have them already ready for you.
Okay, great. And This is great. Yeah, thank you. The state stepped out a minute for
Right.
comfort break, so. Mhm. I think we're in good timing.
Yeah.
Yeah.
Good.
I know, 9 is good, yeah. It's 13 and 15 and that, or 19 or 19.
Yeah.
Yeah, we've done 19 in the mornings for jail arraignments. All right. We have the clerks, we have the state. Counsel, for the public defender's office, you're ready?
Yes, Judge.
All right, great. If everyone's ready, please go on record. Good morning, everyone. We're now ready to begin the misdemeanor bond hearings. I'm gonna announce first the bond outs. Ana Maria Guzman, B 255781, bond out. We have Hazen Shaz McDaniel, B 255782, bond out. We also have Connor Rathbone, B 255786, bond out. Thank you. We have Farrell Rameses Judah Elaton, B 255793, bond out. Michael Anthony James, M 255796, bond out. And we have Todd Jose Montes, B 255797, bond out. Now we're ready to begin with Bargy LaRue Bowden, B 255788. Is that you, ma'am?
Yes,
Good morning.
good morning.
You're here today because you're charged with 1 count of disorderly intoxication, second degree misdemeanor. Your attorney is there to represent you. Give me a minute and let me take a look at the A form.
Mhm.
This was at a gas station. Okay, there's probable cause in this case. Your attorney is here to represent you and state with respect to bond.
That's a standard bond, and it's one day we were.
Okay, let me have the stay away order, please. Ma'am, at this time, I'm issuing a stay away order. You have to stay at least 500 feet away from the incident location, which is 5305 Northwest 36th Street in Miami Springs, Florida. Do you understand? You have to stay at least 500 feet away from that location.
Yes, is that the gas station?
Yes, the gas station. That is correct.
Okay,
All right. You understand that you have to stay at least 500 feet away from that location at all times?
yes, ma'am.
Okay. And with respect to bond? Okay, does she qualify for pretrial services?
I believe so, I don't see any fire for her.
You don't see priors from her?
No.
Okay.
Judge, we would ask for her to be released outright, or I apologize, released on her own recognizance.
You have to speak up a little higher.
Judge, we would ask for her to be released on her own recognizance. She has no priors, and there's no risk to the community or flight risk.
We don't have an objection to that, Judge.
To our order? Okay, all right. Ma'am, I just want to confirm one thing. Do you reside at 221 West 35th Street?
No, I stay at 660 East Drive, Miami. Springs.
Please, a little louder, your address, so you can get notice
I-
next to you.
I reside at 660 East Drive, Miami Springs, Florida, 33176.
Is this a house?
Yes,
And 331?
I think the zip code is 33176.
To be 66, but I'll have Madam Clerk to please check. 660 East Drive, Miami Springs, Florida. Is that correct?
Yes.
Okay, so defendant's address. Address. I put in the back. And at this time, there be no objection from the state. You're going to be released on your own recognizance with the understanding that you have to stay away at least 500 feet from the gas station at all times, and you'll get notice in the mail to come back to court. Do you understand that?
Yes.
All right, thank you. RR, corrections, thank you. Christina Thompson, B 255789.
Your Honor, reset for tomorrow. She went to JMH.
Okay. Reset, 3/24 is tomorrow, right? 25, JMH.
23, Judge, tomorrow.
Today, tomorrow's 23.
Yes, Judge.
Time is going by so fast that I don't
And
lose track of time sometimes. Jacqueline Renee Lee, M 255795. Good morning, Miss Lee.
Good morning.
Ms. Lee is charged, you're charged with evasion of the transit fare, second degree misdemeanor, resisting an officer without violence. Give me 1 second to read the A form. Who's from the airport? Reducing to pay. Okay. Okay, at this time, the court finds that there's probable cause and a public defender's office is appointed. They're standing next to you. State, any priors?
no, Judge.
No priors?
No, Judge.
All right. Ma'am, can you please state your address?
Yes, it's 14165 Washburn Court, Jacksonville 32250.
I didn't hear the address, counsel.
Okay, sorry. 14165 Washburn Court.
How do you
And-
spell it?
Judge, that is Washburn Court.
Washburn, like wash and burn.
Yes, one word.
Washburn, what else?
Court.
Court. And is it a house or apartment?
It's a house and
Jacksonville, Florida. And what is the zip code?
32250.
32250. With respect to bond state?
Judge, standard bond, and we would not object to our release on recognizance, Judge.
Counsel?
And Judge, we would ask that the court release her on her own recognizance. As the state previously said, Ms. Lee has no priors. She's not a flight risk or a threat to the community. She resides in Florida.
Any objection to our order?
No, Judge, she does live out of state,
Not out of state,
not out of state,
out of county.
out of county.
But not out of state. She lives in Jacksonville, Florida. Out of the county, but not out of the state. And she can zoom in. Ma'am, you're gonna have a hearing in this case. You're gonna have to either zoom in or come in person. Jacksonville's a little bit far away, but you're gonna have to at least, at a minimum, be on Zoom. Do you understand that?
Yes, I do.
Otherwise, a bench warrant will issue and you'll be picked up on the bench warrant. You'll be back where you are right now. You understand?
Yes, I do.
When are you going back to Jacksonville? Anytime soon, or you're gonna be here in Miami?
I was supposed to leave yesterday.
Judge, could we do PTS on this? I don't know.
I think pretrial services, you have to have a Miami-Dade address, or it could be anywhere in Florida. With pretrial services, Miami, it has to be a Miami address.
Understood, Judge. The state has no objection to our.
Okay, they'll be released on your own recognizance, understanding you have to come back to court, ma'am, for these charges. If not, you
Okay.
get a bench warrant. Thank you.
Thank you.
Case.
Your Honor, RR, both counts.
RR and both counts, right, both. Thank you. Thank you, Ms. Terry. Next case, we have Carla Elvira Dominguez Ruiz, AL 83XME. Let me
Your
have,
Honor, she also has a related felony. She'll be back on your bond hearing calendar.
okay. All right. Miss, we have Carla Elvira Dominguez Ruiz. You're charged with driving while license suspended knowingly. This time, the court finds that there's probable cause in this case. Public Defender's Office is appointed. I'm going to issue a no drive order. You cannot drive in the state of Florida until you have a valid driver's license. Do you understand that?
Yes.
Okay, and with respect to bond,
No objection, to standard bond, Judge.
counsel?
Yes, Judge. We would be asking that Ms. Dominguez Ruiz be released on her own recognizance.
Go ahead. You need to speak.
Judge.
into the microphone.
Yes, Judge. We would ask that Ms. Dominguez Ruiz be released on her own recognizance. She has minimal priors, none are violent priors. She resides within Miami. She's not a flight risk. So we would be asking.
What is your address, ma'am?
6761 Northeast First Court, Miami, Florida 33138.
Any apartment number? That's a house.
Apartment 2.
Number 2. Okay. Address, it's been noted. I'll go ahead and do pretrial services, alternate bond, 150. Any objection to that?
No, Judge, thank you.
Okay, all right. And I've noted her address. Thank you, ma'am. And the no drive order is in effect. Thank you. Next, we have Livan Noah Alvarez, M25 5799.
Your Honor, NBC reset for tomorrow.
Okay. Not brought to court, reset. Is there a reason I should know or note? Okay, there's no reason, okay. Next, we have Sina Kaid, B25 5714.
Yes, Judge. I have Mr. Kaid.
Your Honor, these are added charges.
Okay, all right. Mr. Kaid, you're here today because you're charged with 1 count of petty theft, first degree misdemeanor on B25 5714. You're also charged with another count of petty theft, first degree misdemeanor on B25 5713. And at this time, your attorney is here to represent you. There's probable cause in this case. And state.
Yes, Judge, the state would be asking for a felony hold. This defendant has an open grand theft charge from 2001 and another open grand theft charge from 2005. Additionally, has burglary and burglary in schools open charges.
Okay, what are the felony case numbers?
Yes, Judge, one moment. Excuse me. My apologies, Judge.
Here's a grant theft case number F255827.
Okay,
Grant theft 8255807.
okay, all right, so, and those are open cases?
Yes, Judge.
Okay,
And one more. Do you want the
go
felony?
ahead, go ahead.
F25005762.
Okay, and these are open cases at this time?
Yes, Judge.
All right, corrections, it's my understanding that he has 3 open felony cases, F255827, F255808, and F255762. There'll be a hold on those cases at this time.
And Judge, I do have a stay away order in this case.
Okay,
Your Honor, I'm sorry, I'm sorry, I don't want to pronounce his name incorrectly. But he's already in custody on F255762. He was given bond on 320 by Judge Fertil. Also on F255807, he was given a bond of 5,000. And he was already taken into custody on F243026, no bond.
okay, all right, no bond. Okay, so no hold needed at this time therefore, and I'll note that 5762 on 320 there was a bond, on F255807 bond was also set, and he is no bond on F255827. I'm issuing a stay away order at this time, sir. You have to stay away at least 500 feet from 11040 Southwest 14th Street in Miami. Do you understand that?
Yes, Your Honor.
Okay, thank you. And we can do a $1 bond in each since he has a hold.
Yes, Judge.
Okay, so $1 bond in each case. Thank you. Next. Have Rosalino Vasquez Morales, B255710.
Judge, for this case, the state would have an announcement.
Go ahead.
In the case of Rosalino Vasquez Morales, case number B25005710, state announces a no pass under discretion.
Okay, at the state's discretion, they have no process or dismissed B255710, Rosalino Vasquez Morales for the record. Thank you.
Yes, Judge. Mr. Vasquez is just entering the courtroom now. I can give him that information.
Just give them that information. Be released. Okay. Next case, Armando Pumares, M255767.
Same situation with this case, Judge. We have an announcement.
Go ahead and make the announcement.
Thank you. In the case of Armando Pumares, case number M255767, the state announces a no pass under discretion.
Okay, the case has been no crossed by the state on Armando Pumares, and that he'll be released.
Thank you, Judge. We just informed him.
Thank you. Next case, Benjamin Valentin Lewis, B255784.
Your Honor, Joanne Hennessy here for the city of Miami Beach. This is the state's case at this point.
Yes, I see the resisting. You're right. And the false name. Good morning, Mr. Lewis. Can you hear me?
Yes, I can hear you loud and clear.
Okay, Mr. Lewis, good morning. This is case number B255784. You're here today because you're charged with the following: resisting an officer without violence to his person, first-degree misdemeanor; giving a false name or ID after arrest, first-degree misdemeanor; camping where prohibited in the city of Miami Beach, which is in violation of your ordinance. At this time, your attorney is there to represent you. Give me a minute to read the A form.
And Judge, we do have a probable cause argument to make in this.
On which charge?
On the camping prohibited by Miami Beach.
Give me 1 second. Before you make your argument, just give me 1 minute. Addressing life concerns. A male sleeping on South Point, covered from head to toe. Go ahead and make your argument, please.
Yes, Judge. According to the four corners of the A form, the officer is alleging that Mr. Lewis was found lying on a blanket and underneath a towel. However, the ordinance that controls this case, it implies that it has to be within some type of temporary structure set up on the beach. He was not enclosed within any walls. He did not have anything holding the blankets up to keep him out of sight of the public. He was simply lying on the beach on a blanket while also being under a towel, which is typical beach activity. We would argue that this case should be, that the camping prohibited charge should be dismissed based off of failure to allege the appropriate facts.
Yes, Judge, I'm sorry. I'm having a little bit of trouble hearing.
I know. I had to raise the volume here too.
But Judge, what I did hear, and I just want to clarify, is that it has to be within an enclosement. Is that what you said?
Not only an enclosed split structure, but it's either the enclosed structure or some type of temporary structure that would block the vision from the public. In this case, he's simply lying on a blanket on the beach with a towel over him. It would not amount to camping.
Judge, I believe that in South Point Pier, and we can ask you to take judicial notice, South Point Pier does have different pillars, and there is a bridge there. We do believe that he could have been covered by some sort of wall or bridge.
Because he was covered from head to toe, the blue blanket.
And that as well, Judge. So he was obstructed from public view.
And using a blue and white towel to lay on and a gray backpack. But it says covered from head to toe, and you said covering is required, and that's what it appears here. They're covered from head to toe with a blue blanket. At this time, the court finds that there's probable cause. Your argument, however, is noted for the record, counsel. And with respect to, sir, it appears you're on house. Is that my understanding? Any priors?
Yes, Judge. Actually, this time it has open cases. I have a case number for you. It is a student lascivious from 4/9/2025, trespassing a school as well and resisting without violence. We would be asking.
Do those have any court dates? Are they in a homeless calendar by any chance?
Not that I can see here, Judge. Give me 1 moment to see if they've been set anywhere. I see that they are in Judge Rostondo's courtroom.
What are they set for?
It's in 6-7. It's in the jail division on this calendar.
6-7, Judge, and it's set for April 9th, 2025.
Can we are more instead of for April 9, 2025?
We would be asking still for a bond, Judge, just given the priors, and additionally, that there's another resisting charge in this case with a false name for us.
Judge, we,
It's already on April 9th. He doesn't show up. He'll get a bench warrant and be back where he's at right now. Sir, if I give you a date to come back, which you already have set for the other cases, are you also going to come back for this case so that you can hear everything on April 9th at 1351 Northwest 12th Street in Miami, Forum 6-7? If I let you go, are you coming back? Or are you going to have a bench warrant be picked up and be right where you are right now? Can I get an answer from you, please?
Yes, please.
Okay, so
yes,
what date did I give you?
The 7th, I believe.
Judge, I believe it was April 9th.
Okay,
I
All
have
right.
it written here on a paper.
he has to come back April 9th for the other charges as well, so that's a date you should have already memorized, sir. If you don't come back to court, they're gonna pick you up. You're gonna be right where you are right now, and you're gonna have to see my face again.
Did you?
You understand that?
Yes, if I don't come, I have to see your face. Yes.
And not just that, you'll be in custody, you'll be arrested,
All right.
okay? And there will not be a second opportunity to be released and coming back with a date. When is it that you have to come back?
6th and the 7th.
No.
April 9th, Judge.
Oh, April 9th. Oh,
I've already asked you twice.
April 9th.
Judge, I can clarify with Mr. Lewis and make sure he fully understands the date. I've written everything on a piece of paper for him.
I believe seeing you. Can you tell me what day you have to come back, Mr.
Okay.
Mr. Lewis?
April 9th, 2025. Okay.
At what time?
8:30 a.m.
Okay, all right, what courtroom?
6-7.
I'm gonna note on here, if defendant fails to appear, issue elevated bench warrant, you are now on notice. Okay,
Okay.
thank you. ROR and place please on the unhoused calendar for April 9th at 9 a.m. Defendant has received oral notice. Next case, Juan Carlos
All
Montoya,
3 counts, Your Honor.
all 3 counts. Thank you. Next case, Juan Carlos Montoya, B255785. Mr. Montoya, good morning. You're here today because you're charged with 1 count of petty theft. It's a second-degree misdemeanor. There's probable cause in this case. Your attorney is here to represent you. Do we have a stay away order?
Yes, Judge.
I'm issuing a stay away order in favor of the Publix located at 1100 6th Street, Miami Beach, Florida 33139. You have to stay away from that Publix at least 500 feet. Do you understand that?
Yes, ma'am.
Okay. Failure to do so will result in being arrested. If you're found guilty, you can face jail. Now, with respect to bond, do you reside? What is your address, sir?
17000 Northeast 23rd Ave, apartment 6, North Miami Beach, 33162.
We'll add the apartment number.
Apartment 6.
Number 6, we'll go ahead and add it. There's a stay away order in place with respect to bond.
Yes, Judge.
Priors.
Yes, Judge. This defendant has 2 open petty theft cases. And additionally, they have a conviction for petty theft from 2024, as well as a resisting without violence conviction, a 2019 petty theft conviction, and a resisting without violence.
So he
as
has
well.
2 convictions.
Yes, Judge.
3 convictions.
Yes, Judge. And I believe he has more. Apologies, Judge. I know that we have some issues with priors, but he does have more than I'm saying, Judge.
Okay.
2024.
Counsel, anything you wish to say as to bond?
Yes, Judge. Well, we would be asking for Mr. Lewis or for Mr. Montoya to be released out on his own recognizance. Although he does have convictions, those convictions are from 2015. Every other thing that's on his record is a withhold of adjudication or no action. That being said, he does reside in Miami. He's not a flight risk. There's nothing besides the 2015 charges to indicate that he has any history of being a threat to anybody. And he also has to work in order to support himself and his family.
Judge, if I may.
Yes.
This defendant does have a 2016 battery domestic strangulation. In addition, has robbery carjacking from 2016, battery second prior conviction as well from 2016, and from 2015 has battery on the elderly, grand theft from 2014. There are multiple felony priors, multiple petty theft related offenses, and at this time we would be objecting to release on the cards.
Okay, standard bond 150?
No, Judge, we would be asking for an elevated bond of at least $1,000, Judge.
Judge, if I may, that would, for Mr. Montoya, that would be tantamount to no bond. We would ask for a standard bond to be placed if the court's not inclined to grant ROR.
Standard bond 150 is set at this time. Thank you. Daniel Higgins Pay, M255787.
Refuse court, reset for tomorrow.
Okay. Next. Juan Escobar Asicona, B255790. Mr. Asicona, good morning.
Judge, he will need the assistance of the Spanish interpreter in this matter.
All right. Do we have the Spanish interpreter?
Here.
Mr. Escobar, please raise your right hand to be sworn.
Señor, le pido que levante la mano derecha para prestar juramento.
Go ahead, Mr.
Do you plan to tell the truth, the whole truth? If so, say I do.
Juro decir la verdad, toda la verdad y nada más que la verdad. En caso de que se diga, lo juro. Juro decir la verdad.
Judge, this is Mr. Juan Escobar.
Yes.
We do have an announcement in this case.
Okay, we have an announcement to this regard. Go ahead.
In case B255790, the state announces a no pause under discretion.
Okay, state has dismissed the case. Thank
La
you.
fiscalía retiró la acusación, ya está, se canceló el cargo.
Okay. Shannon Deshaun Garrison, B255791 is the next case we're gonna hear.
Judge, I apologize. What was that name?
Shannon Deshaun Garrison.
Yes, Judge. I do have Mr. Garrison here with me currently.
All right. Good morning. You are here today because you're charged with 1 count of cannabis possession, 20 grams or less, suspect cannabis, first-degree misdemeanor, resisting an officer without violence to his person. Okay, at this time, the court finds that there's probable cause in this case. Public Defender's Office is appointed. State.
Yes, Judge, this defendant does not have any priors.
Okay, all right. It appears to me that you're unhoused. Is that correct?
Do you have an address? No. Judge, yes, Mr. Garrison is currently unhoused.
Okay, Mr. Garrison, if I give you a date to come back to court, that date would be April 23rd. That means at the end of next month. If I give you that date to come back to court at 1351 Northwest 12th Street in Miami, courtroom 6-7. Are you going to come back?
Yes, ma'am.
All right. Any objections, state or?
No objection.
Okay, I'm going to go ahead and place you on the calendar for April 23rd at 9 a.m. Courtroom 6-7. It's the courthouse near the hospitals, Jackson Memorial Hospital, Hospital, the Sylvester Cancer Center. If you fail to appear, a bench one will issue. You'll be right where you are right now. Do you understand that?
Yes, I do, ma'am. Thank you.
Okay. So I'm noting that if you fail to appear, bench one will issue oral notice.
Both counts?
And that's on both counts. Thank you. Next, we have Brandon Raul Ramos, M255790, 5792. Yes. Good morning, Mr. Ramos.
Good morning.
Mr. Ramos, you're charged with 1 count of battery and 1 count of resisting an officer without violence. Your attorney standing next to you. Let me read the
You have to stay away from this case, Judge.
Yes, if I can have it, please.
Thank you.
At this time, the court finds that there's probable cause in this case. Public Defender's Office is appointed. I'm issuing a stay away order, sir. You have to stay away from Xavier Garcia. At least 500 feet away from him, his home, his place of employment, and school at all times. All contact is prohibited. That includes in person, through third parties, in writing, by telephone, social media, texting, electronic contact. Do you understand that?
Yes.
All right, it's been entered. With respect to bonds,
Yes, Judge, this defendant has multiple priors, including grand theft and 2 batteries, as well as fleeing and eluding. For this reason, we would be asking for an elevated bond of 3,100.
on the battery.
On the battery, Judge, and then we could do on the order.
And Judge, it's a defense's position that Mr. Ramos should be released on his own recognizance. As per the A form, Mr. Ramos is currently unhoused. Any amount of bond would be tantamount to no bond for him, which in misdemeanor case,
He's fighting people. He can't keep his damn hands up.
which in misdemeanor cases wouldn't be the appropriate sentence or appropriate.
And you said what would be appropriate? I'm sorry.
Judge, we would be asking for him to be released on his own recognizance or entered into the TAP program, since he is unhoused currently.
And there's objection to tap alternate bond 3,000.
We would not object to alternate bonds with TAP. We would object to the release of the recognizance, Judge, just because of the multiple batteries.
But I don't think TAP would accept him. Counsel, I am not going to release him on his own recognizance. I'm not inclined to do that. And give me 1 second. You need me to sign this
Yes, Judge.
right here. And I'm counting. You'll take care of that. Thank you. All right.
I'm
Judge.
sorry, Your Honor. Are you placing a hold on B25-1467?
What case is that, State? Can you repeat the case number, please?
B25-1467.
Okay, and that case, is it a probation? Is he on probation on that case?
That's an open DV, Your Honor.
Open DV. Yes, if it's an open DV, there will be a hold in that case.
I'm sorry, it's not a DV. It's a battery, but it's not a DV, Your Honor.
Okay, so it's a battery, but not a DV. Okay, so it's an open battery. Is
Judge,
it related to this charge? Give me 1 second, counsel. They're gonna check on something and hold your thoughts so you can
yes.
put it on the record.
Give me 1 second. Opening the arrest form now. Yes, Judge, I believe it is. It's a different victim, Judge. And it was during when he was, I believe, housed. I don't believe that it's related, Judge. However, because of that open charge, in addition, we did find that he does have other felonies and resisting without violence, Judge. We would be objecting again. And reckless driving, fleeing and eluding. It does not seem that there is a change on this individual's.
Do you want the court to put a hold on B25-1467? That open battery case, does it have a court date coming up?
Let me see if we have the court date, Judge.
We have 4/22.
4/22.
Courtroom 410.
Okay, all right.
Yes, yes, so we would be asking for a hold on that.
You're asking for a hold on that? Usually we don't do misdemeanor holds.
Understood, Judge. In the alternative, we would just be asking for an elevated bond, 3,500.
Okay, all right. Does he have a bond in that case?
We're checking now, Judge. It was $2,000, Judge.
Okay, all right. Counsel,
Yes, Judge.
I see here that it appears that he may be unhoused.
Yes, Judge. He, based off my conversation with Mr. Ramos, he is unhoused. It's a defense's position that, you know, any excessive bond in this case would be equivalent to no bond. We would ask that the standard bond be set in this case. That way it gives Mr. Ramos a chance of actually paying that bond.
Yeah, as to count one, I'm going to set a bond of $2,000. As to count two, it will be $1 bond. And if he does not bond out, he will see the jail division judge on Monday. I believe it's Monday or Tuesday. He'll see the division judge, okay? Thank you. All right.
Yes. And just to clarify, Judge, was there a hold placed on B251467?
No hold.
No hold. Thank you, Judge.
All right, next case, Nicholas Trent Keck, KECK, M253195. Mr. Keck? Good morning. Good morning, sir. You're
Yes.
here today because
Yes,
you're
good
charged with
morning.
good morning. You're charged with one count of trespassing property after warning. A bench warrant was issued for your failure to appear before the court on March 19th.
Yes,
You did not appear.
Did you have a stay away order for this?
There's a stay away order already in place, which I will remind you of, that you have to stay away from Brickell City Center, located at 701 South Miami Avenue, Miami, Florida, at least 500 feet away from that location. Do you understand that?
Judge, I apologize.
I just really want to talk if possible,
Mr.
Judge,
Keck.
like literally.
Okay, sir, you have to, I'm gonna remind you of the stay away order. You have to stay away at least 500 feet from Brickell City Center at 701 South Miami Avenue. Do you understand that?
Yes, ma'am.
Okay.
I just was wondering, is there any chance that I could get an OR based on the fact that I have a $700 flight? I was only here because of they waived my presence at the on March 19th. I went there on March 16th to the public defender's office and they waived my presence. And then I had officers come up to me and then they told me that I had a bench warrant. I was here just for spring break until Monday and then leaving. I just am trying to catch my flight, literally.
What is your address?
480 South, 400 East, Kokomo, Indiana. And that is, yeah, the zip code is 46902.
Is that an apartment or a house?
It's a household.
Okay, all right. 480 South.
400 East, Kokomo.
480 South, 400 East.
Yes, Kokomo.
Indiana,
Yes, ma'am.
469. Okay, I've noted that this is your address. And
I just really need to catch my flight though, if possible. I really do.
Mr.
I'm going to convert the bench warrant amount to a bond amount of 150. Thank you. Next, Riley Fitzgerald Hanson, B255794.
Sir,
That was already.
Next case is Hanson, Riley Fitzgerald, B255794. Mr. Hanson, good morning. You're charged with one count of petty theft. This is second-degree misdemeanor. At this time, your attorney is here to represent you. There's probable cause in your case. I'm issuing a stay-away order from the target located at 1906 Ponce de Leon Boulevard in Coral Gables, Florida. You have to stay at least 500 feet away from that target. Do you understand that?
I understand, Your Honor.
Okay, all right. Now, with respect to bond state, sir, what is your address? Are you unhoused?
Where's your permanent address?
Well, I'm staying at a hotel. I just moved out. My lease is away from the target.
Judge, Mr. Hanson is currently in a situation where he is in temporary housing until he can find a more permanent situation. He's currently staying at a hotel in Coral Gables, which is away from the incident location.
Okay. I don't have an address for him.
I can.
Would be objecting, judge, to any sort of standard bond or release on our part. Since this defendant has 2 counts on a felony case open, I can give you the case number.
Go ahead.
F25002312, criminal mischief and deadly missile throwing.
And what else?
Deadly missile.
Okay, all right. And you said there's 2 felony cases?
2 counts under this felony case.
Oh, 2 counts. So Corrections on F-25-2312, the court will place a hold.
Yes, Your Honor.
Okay, and with respect to this charge,
Yes, Judge, we would be asking for an elevated bond amount of $500.
okay, so for the petty theft, which is an M2, given the fact that he has a felony hold, it will be standard bond of $150.
Judge, would the court be inclined to grant a $1 bond for Mr. Hanson since he does have a felony hold?
Because he has a felony hold, there'll be a $1 bond. No,
Thank
no objection to that. Does the state have any objection? Yeah, he has a felony hold.
Judge, we would be asking for the standard bond nonetheless.
I will grant counsel's request $1 bond, given that he has a felony hold. Corrections, you have that F-25-2312 felony hold?
Yes, Your Honor.
Thank you. Appreciate it. Kelly, Mustaki, Nortellis, M24-162-68. Nortellis.
Yes, Judge, and Mr. Montez will need the assistance of the Spanish interpreter.
Okay, give me 1 second. I see what it is. Okay, all right. Mr. Nortellis, please raise your right hand to be sworn.
Judge, I apologize. This is not Mr. Mortalis. This is Mr. Jefferson Castillo.
Okay, I need it. Mr. Nortellis.
Yes, Judge.
Thank you. Appreciate it. Heli Mustaki Nortellis. Case number M24-16268.
Your Honor, he has an open felony, F-25-5870. He'll be back on your bond hearing calendar. Also, he's held on an AC no bond, F-24-22269.
Okay.
Judge, and I don't believe I have this case coming up in my calendar.
For Mr. Heli Mustaki Nortellis, M24-16268. He has a bench warrant for failure to appear before the court on November 19, 2024. It appears that he put this matter on calendar twice, December 11th and February 6th. And both times he failed to appear and the court issued a no ruling. It's my understanding as an AC no bond on F-24-22269 and an open case where he's going to be at bond hearing in a few minutes. And he is charged with 1 count of trespassing property after warning. Any objection to a dollar bond since he's going to be seen, he's going to be a felony and he's got an AC no bond?
Just for the record, we would object. He does have multiple open cases. It's not just this one, Judge. Also, felonies, criminal mischief, trespass property after warning, and it will be.
I'm sorry, State, can you talk into the mic? We can barely hear you.
Yes, for the record, we would be objecting. He does have multiple cases open, including cocaine, indecent exposure, drug paraphernalia, resisting officer without violence, as well as one moment. Lord,
he has an open case, F-25-5870, that he's going to be go to that bond hearing.
He's coming for bond hearing.
Yeah, it's going to be a $1 bond in this case, given the fact that he has an AC no bond F-24-2269 and an open felony that he'll be go before bond hearing for that in a few minutes. Okay, thank you. Next is Delmar Williams Jeffrey.
Your Honor, this is an added charge. He's already held no bond on F-22-14883 Bravo. And also, that's it, Your Honor, I'm sorry.
Okay, all right. At this time, Mr. Jeffrey Delmar Williams, you're here today because you're charged with driving while license suspended knowingly and you failed to appear before the court on February 14th and a bench warrant was issued against you. At this time, I'm issuing a no drive order. You cannot drive in the state of Florida until you have a valid driver's license. Do you understand that?
Yes, ma'am.
Okay, he's been held no bond.
yes, Judge. We don't have an objection.
$1 bond? $1 bond. Thank you.
Thank you, Judge.
Thank you, Judge.
It's going to be Jefferson Castillo Gill, AKK 606E. Mr. Gill, good morning.
Good morning.
You're charged with operating a motorcycle without a driver license, sir.
Judge, he will need the assistance of the Spanish interpreter.
Mr. Interpreter, can you, sir, can you please raise your right hand to be sworn?
Señor, levante la mano derecha para prestar juramento.
Do you swear to tell the truth, the whole truth, nothing but the truth? So say I do.
Juro decir la verdad, toda verdad y nada más que la verdad. conteste en voz
Yes,
alta.
yes, sí, yes.
Okay, thank you. Mr. Castillo Gil, you're here today because you're charged with operating a motorcycle without a driver license, sir. And I find no motorcycle endorsement. I find that there's probable cause in this case. A public defender's office is appointed.
Your Honor, I'm sorry, Mr. Castillo is out on felony bond, F-25-2099.
F-25,
2099.
there'll be a felony hold at this time on F-25 2099.
No.
Señor, se le acusa de manejar sin el permiso debido para operar la moto y en ese momento determino que existe motivo fundado para justificar el cargo. Queda designado un abogado de oficio.
Here many times.
Okay, all right. Mr. Castillo, can you please state your address?
Díganos dónde vive, señor Castillo.
Miami, Florida.
La dirección entera.
1005 Spring Garden Road, 528. 33-136, perdón.
1005
Spring Garden Road, 33-136.
His address has been verified. It is my understanding, sir, that you have failed to appear to court many times. It's important that you appear before the court because notice is being sent out to that address. You have an attorney, please make sure you contact them if you have any questions.
Usted no se ha presentado a las audiencias en varios momentos, en varias ocasiones, y se han mandado las notificaciones a esa dirección que se ha verificado. Es importante estar en contacto con su abogado. Ahora tiene abogado, siga en contacto con él.
Okay, at this time, on AKK 606C, $1 bond, given the fact that he will have a felony hold on F-25 2099.
En la causa, en cuanto a la moto, la fianza es de $1, ya que se impone una retención en el caso de delito mayor, en el caso F-25-2099.
Thank you, Judge.
Okay, all right, thank you. Next, Jordan Treto Sardui, AK9 I7EE.
I'm sorry, Your Honor, what was the bond for Mr. Castillo?
It was $1 given that he has a felony hold. We'll place a felony hold on the case number you gave him. Thank you.
Thank you.
Corrections. Next case, Jordan Trejo Sardui, AK9 I7EE. Mr. Sardui, good morning.
Judge, Mr. Sardui will need the assistance of the Spanish interpreter.
Please raise your right hand to be sworn.
Levante la mano derecha para prestar juramento, señor Sardui.
Raise your right hand to be sworn.
Juro decir la verdad, toda la verdad y nada más que la verdad.
Juro, señoría.
I swear, Your Honor.
Mr. Sardui, you're here today because you are charged with, looks like driving while license suspended knowingly. And you failed to appear before the court on November 12, 2024. Bench one was issued.
Se encuentra aquí porque al parecer se le acusa de manejar con la licencia suspendida a sabiendas y también porque usted no se presentó en el juzgado cuando se le exigía presentarse el día 12 de noviembre del año pasado.
Bench one was issued. Can you please state your address?
En tal fecha dictaron orden de captura. Por favor, dígame la dirección suya.
Mi dirección ahora, la que me prestaron es 1621 North 71 Avenue, Hollywood, Florida.
The address where he gets mail, because he said the address where they arrested me. The address where he gets mail, please, if you can.
Díganos, señor, la dirección donde usted recibe la correspondencia.
Judge, if I may, the paperwork I have here currently reflects that Mr. Sardui is unhoused.
Okay. Right.
Señoría, permítame decir una cosa por lo que tengo aquí en los papeles. Aquí pone que el señor Sardui no vive en la calle.
Vivía en la calle antes, señoría.
I was unhoused before, Your Honor.
Okay, sir, where do you reside? If you have a mailing address or a residence address, is that something you can share with us?
¿Dónde vive ahora? ¿Tiene un domicilio fijo, un lugar donde podría recibir la correspondencia?
Vivo en la calle, lo que me prestaron esa dirección de Hollywood ahora para recibir mi correspondencia, ya que estoy recibiendo los FUSTAN que me está dando el gobierno de Norteamérica, de los Estados Unidos.
Okay.
Well, I have that address in Hollywood where they arrested me for receiving
Yes, Judge, haven't been able to hear what they're saying. Said date to come back, but yes, Judge, he only has one prior.
He says he's unhoused. He has an address in Hollywood that they gave him so that he can get his mail there, but he is unhoused. Can we do ROR and homeless calendar?
Yes, Judge.
Okay, Mr. Sardue, if I tell you that you're coming back to court April 23rd, from 6, 7, and 9 a.m., will you be doing so, sir?
Señor, si yo fuera a decirle que le toca volver al juzgado el día 23 de abril a la sala 6-7 va a venir.
Sí, señoría. Correcto,
Yes.
señoría. Lo juraría, señoría.
I would swear, Your Honor.
Okay, all right. I'm issuing a no drive order. You cannot drive in the state of Florida until you have a valid driver's license. And I'm going to release you on your own recognizance with the understanding you have to come back April 23rd, 9 a.m. for 6-7. Failure to appear will result in a bench warrant.
Señor, con eso entendido que mediante orden judicial le queda prohibido volver a conducir aquí en el estado de Florida, usted va a poder salir bajo palabra de honor. Con eso entendido que va a volver al juzgado para presentarse el día 23 de abril a las 9 de la mañana a la sala 6-7 y en caso de que no venga, se va a dictar una orden de captura.
Gracias, señoría. Gracias, señoría.
Thank you so much, Your Honor.
All right. Next case, Cosme Daniel Garcia Jr.
Judge, I'm here with Mr. Garcia.
Mr. Garcia Jr., good morning. You're here today because you failed to appear before the court on March 10th and a bench warrant was issued.
Yeah, then the state would just like to make the court aware.
What is the charge in this case?
The charge isn't no motorcycle driver's license, Judge.
Okay, so it's the charge is for driving a motorcycle or operating a motorcycle without an endorsement. Can you please state your address?
Currently I'm homeless. I'm homeless right now.
Okay. Go ahead, state. You were gonna say something?
Yes, Judge, this defendant has failed to appear since 2016. We'd just like to make the court aware of that. We understand that the charges are no motorcycle driver's license, but we would at least ask for a strong recommendation to him.
Okay, all right.
Judge, it's a defense's position that although Mr. Garcia might have a failure of not appearing, we can put him on the homeless calendar. We can give him notice today, which gives him a strong chance of appearing in court. And if not, he will receive another bench warrant and he'll be right back here. We would ask for an ROR and we'd ask for him to be placed on the homeless calendar.
Eric, I tell you that you have to come back to court to answer to this charge. Are you gonna come back on April 23rd at 9 a.m. in courtroom 6-7? Or are you going to bench one and be back where you are right now?
No, I'll go ahead and
You'll be coming back to court April 23rd?
Yes, ma'am. I knew I
Do you understand that if you fail to appear, bench one will issue? Do you understand that?
Yes, ma'am.
Okay, all right, so now you're on notice. And I'm giving you oral notice that you have to be back April 23rd at 9 a.m. quorum 6-7. I'll release you in your own recognizance. You're getting notice, your attorney is writing it down so he can give it to you. ROR and the homeless calendar, April 23rd. Thank you, sir. We'll see you April 23rd. Not a bench one will issue. Thank you. Next case, Devin Hector Lopez, AG8W77E. Mr. Lopez, good morning.
Good morning.
You're here today because it says you were charged with driving while license suspended knowingly. A bench one was issued for your failure to appear in court April 20th of 2024. At this time, I'm issuing a no drive order. You cannot drive in the state of Florida until you have a valid driver's license, sir. Can you please state your address?
2301 Laguna Circle, apartment 306, zip code 33181.
What is the city and zip code?
The city is North Miami and the zip code is 33181.
2301 Laguna Circle, number 306, North Miami 33181.
Yes.
Okay, so it's a different address. All right, okay. I'll go ahead and reflect it on here that this is your new address. And state, I'm issuing a no drive order. You cannot drive in the state of Florida until you have a valid driver's license. You understand that?
Yes, ma'am.
Sure you understand that. Okay. Failure to abide by the court order can result in jail if you're found guilty of failing to abide by a court order.
Yes, Judge, we would not have any objection to standard bond. We do not say that he has local powers, however, he does. His place of birth is in New York.
See what?
His place of birth is in New York, but we do not say that he has any local priors.
How long have you been here in Miami?
I would say about 2.5 years, maybe going on 3.
What about Fort Lauderdale?
Yeah, same amount, because I was in Fort Lauderdale first, and then I moved to North Miami.
So, but in Miami, how long have you been in Miami? At this North Miami address?
I would say I just had my 15-month lease, so 1.5 years.
Okay, all right. Counsel for the defense?
Yes, Judge, we would be asking for him to be released on his own recognizance. This is a bench warrant stemming from a driving with a suspended license case. As the state said, he has no priors, and he's not a threat to the community. He's not a flight risk, despite the fact he's only lived at this address for about 1 year. We would move for him to be released on his own recognizance, Judge.
And so just say has no objection, given that we do not see local priors.
ROR. Sir, you have to come back to court. I'm gonna release you on your own recognizance, understanding you have to come back to court. If you change your address, you have to let the clerk of court know. You understand that?
Yes, ma'am.
Thank you. Next, Jonathan Chacon.
Your Honor, he also has an open felony F-25 5884. He'll be back on your bond hearing calendar.
Okay, all right.
Judge, I have Mr. Chacon present before the court with me.
Thank you, Mr. Chacon. On AKYB2YE, a bench warrant was issued against you for failure to appear before the court on March 19th. The charge is driving while license suspended knowingly. Mr. Chacon. On AKY8M4E, you're also charged with driving while a license suspended knowingly, and a bench warrant was issued for failing to appear before the court. And at this time, I'm issuing a no drive order. You cannot drive in the state of Florida until you have a valid driver's license. You understand that?
Yes, ma'am. Yes, ma'am.
Okay, all right. I heard yes, ma'am, no drive order. And with respect to bond in this case, I'm setting bond at 150 each case. One bond will be the standard bond, 150 each case. Thank you. All right, at this time, we've concluded the misdemeanor calendar. We'll take a 5-minute break and we'll be off record for 5 minutes. Court will resume at 11:10. Thank you.
Your Honor, this is Joanne Hennessy. I'm here only for the misdemeanor calendar, if I could be excused.
Thank you, May. Thank you. I'll go to chamber for 5 minutes. Oh, okay. You can hold for the clerk. Yeah, thank you. Appreciate it, Ms. Terry. Okay, I'll be back in 5 minutes, okay? Thank you. Just give me 5 minutes. You too. I think this was pretty good. This looks great. Okay, good.
Thank you, Judge.
Great. All right. How many pages? We have to tell you, we'll be doing now.
13 pages, Your Honor. No, that's really small.
Oh, it's pretty small?
Yes.
It's big for me. I don't do that.
Mr. Interpreter?
Okay, it's a lot for me to go.
Yeah.
Sorry.
There were, I can assume, I know she read them really fast in the beginning, but the cases that we did not.
We need someone, we need a Russian interpreter for gentlemen on the felony calendar.
Literally just go put in the water.
Okay. It's okay. It's okay. It's okay. Well, if you want, if we call, I can call forward or vice versa, it doesn't matter.
Oh, really? Oh, yeah?
Right.
All right.
Morning. I guess, no, actually, I think it's gotten a little chillier at least. Maybe they turned it on. What happens? They turned it off during the week. I guess. Do you know what happens with cases that are reset? They just go back on the calendar, right? Okay.
never brought down the copy of me.
It's okay.
I have a copy of the local priors. I told the judge.
Now,
You
so
know-
what I was reading, you
No,
guys-
no, I didn't know what you were saying, but I was like,
I don't-
Yes, Eastwood form, 5-8.
Lovely week, huh? God, very nice. I'm glad to be home.
I was just trying to decide that hard work lasts a month and a half.
Yeah, it's been about 2 weeks.
Next up, come down.
That's why she's moving in the right.
Oh,
Right. We got them all. Everybody's.
Oh, thank
you. Yeah, all of it. Who votes? The whole, like, everyone's coming here.
Yeah, Jean is gonna do it, get it both too.
Jean, Percy, I think Jane.
I don't know how. Oh, James will do this.
Jean, sure.
Oh, James. Oh, James. He don't do it.
Okay, good. Where is her staff? Does she have staff?
Okay, so. Yeah, so if you have a bond that you want to recommend to the judge, one, 10,000, $7,500, that's what you decide. Your recommendation to bond, if not, you can tell her that it's over your strap.
Third, violence, 2,500. Third, good violence.
Yeah, and those that, the F ones with the drug targets, they're not changed this time.
Cocaine is not a thing.
Cocaine.
Not counting as one.
Yeah.
It's
You don't
marijuana,
have
it's
to do
heroin and meth.
neutralization.
Okay, and fentanyl.
I see it every month. So that's, I'm like, I know every week they do it and then.
They give you all the motions to fill out. Yeah, there's.
Cause every week you go through the fine.
Yeah.
Yeah.
So you tell them and then like.
Wait, okay, so I didn't understand, and I don't want this happening, because you tell me they can tell them, and they don't.
No, it's not for them, it's the judges as well, the state that like every F1 is a thing.
Oh, so it's not have to be by the.
Okay, but we do keep our teaching, we don't have to keep our teaching, so we can go home and make it beautiful. So, that's what I'm saying.
Yeah.
State knows that you do get a week.
Yeah.
Not going.
Yeah, we just know that they don't give you guys time to report everything, we just know it on you.
Yeah.
You're like telling them that, okay, like, you know, we're trying to push you and then. So the Republican voters are over the. For F1 basis and being done in just times.
Yeah, and ones with some of them are not.
I think
that's
60
right, like,
inserts.
yeah, they-
Yesterday, I didn't.
Yeah. We didn't set a 13-page calendar.
Oh, this is the love one.
It's actually-
Oh, yeah.
And she only has 130.
And it's only, I guess.
I think we'll be done with it already.
Yeah, I hope so.
These are the actions from the source.
Right. Priors, please. Thank you.
get number 9? Thank you. Oh, wait, I'm looking at mine.
Never mind.
Choose. One of those. Page 9.
That's why.
Yeah.
27.
Thank you. Hey, I'm sorry, I told you number 9, it was on page 29, it's number 27.
He's on page 9. She didn't help the numbers mixed up.
We're talking,
Craig Jones on page 10.
page 10.
Yes.
Craig Jones.
Right.
Yeah.
Yeah, we'll give number 27.
No, that's a good thing. We don't have it in order.
Yes.
Yeah.
Okay, and then why don't we go back to these ones? Right, we're done. Okay.
That's all like you pull them out.
Oh, so we're just calling those first?
No, we put them down.
And then we're in. So,
Eric Packard today.
Look, I don't.
Ready? Talking about it there. So
That's all we're making the holiday.
I'm going to say no, 7:25.
My son's too tired of that. He's already sick of it.
Right.
I agree.
You're little, you go on the rides and then you go, there's
Exactly. You don't get sick of it.
No, I'm sick of it. And so am I. It's just that the problem is I used to go there like 4 or 5 times every time.
Oh, see, that's the problem.
Because I lived across the street from the fair.
maybe we'll probably probably pension for the non-violent, but I think it's still faster for them.
Yeah.
Felony, I have the capital on it. Are you saying that?
What's the charge?
The 3 charges, cocaine?
That one, yeah.
Yeah, that's what it is. He's paying cocaine.
Cocaine by itself? No, but you said fentanyl, that's the magic word. That's the magic word right there.
Like the first
Fentanyl, meth, and heroin, I think are the 3 that they really,
cocaine really doesn't qualify as a thing.
which I don't understand.
Maybe they're on like the related.
Oh, man. Yeah, sometimes I look at Renee, I'm like, "Is that what I'm gonna look like?"
You just get the face of Renee. You got it.
Well, you don't, I don't know if it's that often, but it comes to rent judges. I don't think we have to do it during the week, actually, from now.
You know what? That I never actually do that. Maybe you should be doing that when it's not crazy.
I think it's when it's consistent, like how Peralta was consistently there. I don't think so. But if it was like one time, like next week, we're getting like.
I remember in calendar, they used to.
Yeah, he's only for one day. I think
Who?
Wednesday. So, say Wednesday.
Good say, oh, no, that happened with the.
But I'm not sure who the other judges are. I think Jane is covering one of them. I think Young is covering them too. Yeah.
You know, that's the bullshit quick.
Right.
Yeah.
But nobody.
I just moved it all upstairs because he's too much.
Wait till you get Milton. Milton.
I don't remember which church it was.
First with the next week, we call for. The
Hershey.
Sure. The one who calls.
They're both sure. I don't care what you say.
The one who calls the other one the handsome one. He goes, "Oh, you're gonna go see the handsome version." That's the one I put there.
Okay, that's Richard.
Okay, that's what's for.
He goes, "Oh, you're right. The other one." Hello, I'm not used to felonies, so bear with me.
Okay, all right. Okay. So I can fly through misdemeanors. They know, but so good morning, everyone.
Morning, Judge.
Good morning, good morning. I have an afternoon, 1:30, so just one case, so if by any chance I'm not done, I should, okay, excellent. And we have the Russian interpreter present. Can we take our case at a turn? What would the name be for the case that you're here for, Madam Interpreter?
Yes, Your Honor. Good morning.
Good
The
morning. I
case-
recognize you from division, so.
Yes, the case number is Igor Nam.
Your Honor, it's page 3, the first person on page 3.
First person on page 3.
Yes, Igor Nam.
Yes. If you don't mind, we'll take it out of turn so she doesn't have to wait too long.
Thank you, Honor.
Eight on the prior, John.
Excellent, thank you. At this time, if everyone can please stand and raise your right hand to be sworn. Do we have a Spanish interpreter?
Yeah, yes.
Okay, all right. Por favor, todos de pie, levanten la mano derecha para ser juramentados. Everyone, please stand and raise your right hand to be sworn.
Пожалуйста, все встаньте, поднимите вашу правую руку, чтобы вас привели к присяге.
Thank you.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Say I do.
Juro no afirman que el testimonio que están por prestarse a la verdad, toda la verdad y nada más que la verdad.
Вы клянетесь, что все показания, которые вы дадите, будет правда, одна правда, ничего кроме правды.
Appreciate it very much. Okay, corrections. I have been given some out-of-turn cases, and I have been given the regular calendar cases. So we'll call your cases at a turn in a few minutes. But please, if we can begin with Mr. Igor Nam, case number F-25-5878.
He's there, Your Honor.
Present before the court, Judge.
Mr. Nam, good morning.
Здравствуйте, это сейчас вызывается дело вне очереди. Игорь Нам. Доброе утро, сэр.
Доброе утро.
Good morning.
Good morning.
Yes, before we begin, I'm gonna ask that the state attorney's office and the public defender's office each make their appearances, please.
ASA Hunter Pollack on behalf of the state.
Do you have a case?
ASA Milano on behalf of the state.
Okay, you're gonna be.
Assistant Public Defender Christian Maroney, and will Your Honor be appointing the Public Defender's Office for all cases today?
At this time, I'll note for the record that it's my understanding that their rights have been presented to them in a video in 3 languages. In addition to that, the Public Defender's Office is hereby appointed on all cases except where otherwise noted. And Again, as I mentioned earlier, I'll rely on corrections in the state attorney's office for any immigration issues that the court should consider.
And for the record, Judge, Assistant Public Defender Christian Maroney accepting appointment.
Thank you. Igor Nam, Mr. Nam, good morning.
Доброе утро, мистер Нам, Игорь.
This is F-25-5878. You're here today because you're charged with attempting to use or using an inventory device for anti-shoplifting. It's a third-degree felony.
Окей. Значит, вас сегодня обвиняют в том, что вы использовали такой прибор, чтобы не было краж, для того, чтобы совершить кражу. Это уголовное преступление третьей степени.
And one count of petty theft, that's a first-degree misdemeanor.
И один пункт обвинения, мелкое воровство, это правонарушение первой степени.
Okay, all right, so at this time, sir, as you heard, your attorney is there to represent you, and
Да, и сейчас, как вы слышали, ваш адвокат с вами присутствует, чтобы вас защищать.
I find that there's probable cause in this case. I'm issuing a stay-away order. You have to stay at least 500 feet away from 20669 Biscayne Boulevard in Aventura, Florida. And can you specify it's the Nordstrom Rack? Can we do that? The Nordstrom Rack store located at 20669 Biscayne Boulevard in Aventura, Florida.
В данный момент я нахожу, что было достаточно оснований для вашего ареста, и я вам приказываю не приближаться ближе, чем на 500 фитов от магазина Nordstrom Rack, который находится по адресу 26669 Biscayne Boulevard в Авентуре, Флорида.
Okay, all right. With respect to bond, as to count one,
Judge, I'm sorry.
Go ahead, counsel. You were going to say something. You may.
Yes, Judge. So being that Mr. Nam has no priors, it doesn't even appear that he has any previous arrests or any previous contact with the criminal justice system whatsoever. The defense is requesting pretrial services with that stay-away order.
He's only been here for 1 day. It's my understanding, state.
Yes, ma'am. State would request standard bond, given that he is from Russia, and he's only been here for 1 day. We believe because of the flight risk, we would be asking for standard bond.
At this time, the court will set standard bond count 1, 2,500, count 2, 500. Thank you.
Окей, 2,500, 200. Окей. Значит, адвокат защиты попросил, что учитывая, что у него не было никаких предыдущих арестов, и раньше он не попадался, просто дать ему досудебную программу и отпустить его, значит, без какого-либо залога. Прокурор говорит, что нет, он из России, и он здесь всего 1 день находится, поэтому, пожалуйста, стандартный бонд выдайте. И судья говорит, хорошо, значит, по первому пункту обвинения $2500 стандартный залог, по второму пункту обвинения $500 залог.
Okay, all right. Thank you, sir.
Хорошо, спасибо, сэр, до свидания.
Okay, we'll start out of turn now for corrections at their request. Craig Jones, F-25-5894.
Your Honor, this is an added charge.
Okay, thank you. Corrections, can we excuse the interpreter at this time?
Yes, ma'am.
Okay, state, we're excusing the interpreter. Defense, we're excusing the interpreter. Is that okay with both sides?
Judge, if I could just utilize the interpreter to let Mr. Nam know a couple things, because he seems to be very confused.
Not a problem. Go ahead and take your time so we can clear up whatever questions.
Mr. Interpreter, if you could just inform Mr. Nam that he was given a money bond, so to be released from custody, he would have to post some money. Or we might have lost him.
Madam Interpreter?
Oh, maybe. So Judge, it seems like we lost the Russian interpreter. I'll just have, I'll have our paralegals get in touch with another Russian interpreter and they can let him know what to do with the bond.
All right, thank you. Next case, Craig Jones, F-25-5894 and F-25-5859. I heard there were added charges.
Present before the court, Judge.
Mr. Jones, good morning, sir. You're here today because you're charged with 1 count of burglary, occupied structure, 2nd-degree felony, and 1 count of petty theft, 2nd-degree misdemeanor. That's on the case that ends in 5894. The case that ends in 5859, you're charged with tampering with electronic monitoring device. It's a 3rd-degree felony. At this time, your attorney is here to represent you, so the public defender's office, as you heard, is appointed. I find that there's probable cause in this case. I'm issuing a stay away order on F-25-5894. You have to stay at least 500 feet away from Mila Restaurant at Miami Beach, 1636 Meridian Avenue, Miami Beach, Florida, 33139. Do you understand you have to stay at least 500 feet away from that location, sir? I did not hear you.
Yes, ma'am.
Thank you. And that is on the 5890. What number is this? 5894. Yes, the stay away order. Okay, with respect to bond.
Yes, Judge, this defendant does have a prior unlawful possession of stolen credit cards in addition to multiple arrests for larceny, fraud, in addition to Judge, in addition to other burglaries, multiple burglaries, and we would be asking for an elevated bond in this case.
Okay, so with respect to the burglary, what are you seeking? And
Judge, we would be asking for $5,000.
okay, all right. And counsel? Count 1?
Your Honor, Mr. Jones cannot afford an elevated bond, and I don't believe an elevated bond would be warranted in this case.
And you say it's not warranted because?
So, Judge, he's already in custody on other cases.
What is he in custody for? Corrections? Does he have any holds? Is he in custody?
He's in custody, Your Honor, on 3 ACs, no bond.
Okay.
So the defense would be requesting, Judge, that Your Honor just issue a $1 bond since he's already held no bond.
I'm sorry? Yeah, 3 ACs, no bond. I'm gonna write that here. Yeah, these are added charges. 3 ACs, no bond. State.
Judge, we would be objecting to a $1 amount. I understand that he has not holds, but he did pick up new cases, Judge, and given his priors, he's still asking for that elevated bond. And if the defense could speak a little bit closer to the microphone, please.
And the tampering?
For the tampering, $2,000.
And you said for the burglaries, you asked for how much?
$5,000.
Okay. Deciding to stay away this time. And as to the tampering, it's going to be a $2,000 bond. As to the burglary, it's going to be $2,000 bond. And count 1, count 2 will be $1 bond. Thank you. Next case.
So, Judge, it's my understanding that Corrections wants to call number 33, Victor Rodriguez, next.
Victor Rodriguez is the next case that I'm calling. Thank you, counsel. Yeah. Yeah. And they're here, the moms? Yeah, I'll go. Yeah.
44 counts. Not all 44 counts.
Okay. All right, so sir, it appears, may I begin, counsel? Can you hear me?
Yes, Judge, we can hear you.
Okay, I just want to make sure you're not talking to him or busy. If I need to stop, I will. Just let me know, okay? So, Mr. Rodriguez, good morning. If at any time you need to talk to your attorney, feel free to stop me. I have here that you're here because of an arrest warrant, and there's a hold for the Department of Corrections.
Yes.
It appears that there are how many charges you said again? 40 plus?
45.
45 charges. So in this case, you have a hold for 45 charges. Hold, it's 45 charges. And there's an arrest warrant in this case. And I have here a bond amount that is listed in the arrest warrant of $135,000. And it's my understanding it doesn't include all 45 charges. Is that my understanding?
Because if you look right here.
Yeah, it only has 1, 2, it has 3, 4, 5, plus 4 is 9, 10, 17, 18, 19. So it has 19 out of the 44.
But I think they wanted a total bond of 130.
Yeah. So at this time, the court will adopt the arrest warrant amount into a bond amount, and it will be $135,000.
And Judge, sorry.
And then I have to break it down, and let me
Yes.
break it down. Let's start breaking it down.
Judge, we do have a motion for pretrial detention in this case.
Okay, and there's a motion for pretrial detention. And it cannot be heard by the judicial judge, it needs to be heard by the bond hearing judge. It goes to them, okay, all right. Now, let's break it down for corrections, please. Count 1, 15,000 plus Nevia. Count 2, 3, and 4. 45,000. No, 15 times 3. Plus Nevia. Count 3, 4, count 5. 15 plus Nevia, 15,000 plus Nevia. And this is the court adopting the arrest warrant amount into bond amount. 3, 4, 5. Okay. Now, 6, 7, 8, and 9, 6 through 9 will be $7,500 each times 4 is $30,000 plus Nevia. Count 10, 7,500 plus Nevia. Counts 11 through 18, 2,500 times 7 for each, for a total of 7,500 plus Nevia.
You're on at 11 through 19 or 11 through 18?
11, 12, 13, 14, 15, 16, 17. Actually, through 17, because it's supposed to be 7 of them. Through 17, 2,500 times 7, 7,500. Okay. And then
2,500 Your Honor, or 7,500?
2,500 times 7 for a total of 7,500 from 11 through 17 plus Nevia. And then 18 and 19 would be 2,500 each for a total of 5,000 plus Nevia. So the bond adopts the arrest warrant amount, and then we have more charges.
That's why I was pointing out the calendar, all the other charges is not presented.
We are now in number 20. We should start number 20.
It's the 4-3.
Okay. 20 and 21 are each forgery. 2,500 each plus Nevia. 22 and 23.
Thank you.
Filing false documents. 2,500 each plus Nevia. 24 grand theft first degree. What is normally in a grand theft?
Judge, for grand theft first degree, it's normally going to be $7,500 bond. Regular grand theft is $10,000.
7,500 plus Nevia. Count 25. I'm sorry. Count the ID aggravated from first degree.
Aggravated.
ID. Okay, this is what I'm going to do. Counts 25 to 45.
That's usually $10,000.
Are they first degree as well?
Yes.
They did file a motion for pretrial detention for you, seeing if some of them would be held no bond.
Yes,
Okay.
Judge.
Okay, so which ones? 25 to 45? No.
The
Which
ones
counts?
that-
Let me see the motion, I'm sorry. Okay, with respect to the motion for pretrial detention?
Yes.
I'll hear from the state and then from the defense.
Thank you, Judge, in this case, the state is asking for the defendant to be held no bonds. The defendant has 45 counts all related to showing a scheme of fraud, trafficking, fraud, grand theft, as well as fraudulent use of IDs. The defendant, we believe, is a dangerous to the community given the amount of the counts in this case. We believe that the defendant should be held no bond, Judge. We do believe that he poses a danger to the society. He also has other charges for aggravated stalking, kidnapping, and false imprisonment. Some of these have been no cost, Judge, but the defendant has already been offered pretrial diversion in multiple cases as well. He has also organized fraud charges for $50,000 or more. We do believe that this defendant poses a danger to the community if he is to go free.
Counsel for the defense.
Yes, Judge. So I'm looking at the pretrial detention statute now. I don't believe that any of the charges 1 through 45 are included in the definition of dangerous crime, which is what the state can file pretrial detention motions on. These are all white collar crimes. They have to do with, theft allegations, fraud allegations, and none of those appear in the definition of of the definition in dangerous crime under the Florida pretrial detention statute. So I believe that in this case, holding him no bond on pretrial detention is not warranted under that motion. I think a bond of $135,000 is be sufficient. Also, Mr. Rodriguez has already accepted a plea in Tampa to serve 10 years in prison, so he's not going to be going anywhere anytime soon, Judge. So I think that this pretrial detention motion is just duplicative.
And just to make the court aware, this defendant does have out-of-county warrants that he has not appeared for. We do believe that he poses a flight risk and he should not be.
Okay, all right. So at this time, as the court indicated, for counts 1 through 19, the courts adopted the arrest warrant amount of $135,000. The court indicated bonds from counts 20 and 21, $2,500 each plus Nevia, 22 and 23, $2,500 each plus Nevia, count 24, $7,500 plus Nevia, counts 25 to 45. The defendant will be held no bond. At this time, the court grants a motion for pretrial detention, and the defendant shall be detained in custody pending a final hearing on pretrial detention as a result of this court having determined that 1, the defendant has been charged with a dangerous crime as defined by Florida Statute 907.041, subsection 5A, 2, that the offense is a capital felony, life felony, or felony of the first degree, and 3, there's probable cause to believe the defendant committed the offense. Furthermore, the final hearing shall be held in a court of trial jurisdiction within 5 days of the filing of the motion or of the date of the taking the defendant into custody pursuant to the motion for pretrial detention, whichever is later. I am entering the court order at this time.
Your Honor, if I could just inquire for clarification purposes. Your Honor found that he was arrested for a dangerous crime under subsection 5A. Could the court clarify which of the counts qualify for dangerous crimes under that section?
Okay, please ask any further inquiries to the division judge, who will go ahead and make sure that your questions are answered. He's entitled to that hearing. I'll have that hearing. And at this time, the court has ruled. And he's going on Monday. So, sir, Monday you'll see the division judge. Thank you, sir. Next, Rodney Renee Pousley, Poucely. My apologies if I mispronounced. F25 5887.
Your Honor, this also is an added charge, battery by detaining.
And he's in custody on what case?
He's in custody on F25. 2935 and F25 2936.
2926. Okay, all right. Sir, how do you pronounce your last name? My apologies if I mispronounced.
Miss Pousley, I think you pronounced it right, but Dorini, I don't know where is that from. That's not my name.
Okay, all right, thank you. On F25 5887, you're charged for 1 count of battery by detainee on visitor or other detainee. It's a 3rd-degree felony. And at this time, I'm issuing a stay away order. You have to stay. No, because it's a detainee. Yeah. Yeah. So at this time, they'll go ahead and
Sorry, Judge.
It's okay. It's okay.
Maybe if they would be released, we would still need to issue the stay away order.
No, but he's being held, so they'll take care of it.
Okay,
Thank you.
thanks.
All right, sir. So that is the charge. Give me 1 second. Let me read the A form. Okay, the court finds that there's probable cause in this case. Your attorney is there to represent you. And with respect to bond state,
Yes, Judge, the bond that we are asking for is 2,500.
counsel, you want to say anything with respect to that?
Yes, Judge, the defense is just requesting a $1 bond. He's already being held no bond on other cases.
The court sets bond at the amount of $2,500. Thank you. Thank you, sir. Good luck. Next, Leo Gilbert, F-255863. Oh, okay. All right. At this time, we have counsel present. So, any previous appointments the court may have made with respect to the public defender's office or discharge, counsel, your appearance, please.
Thank you, Your Honor. My name is Arthur Jones, standing in for his counsel of record, Larry Hanfield.
Arthur Jones.
And I'm so sorry, Judge. Could I inquire who this individual is?
He is counsel, Mr. Arthur Jones, standing in for attorney of record, Larry Hanfield.
On which case?
On the case of Mr. Leo Gilbert, F-255863. Good morning, Mr. Jones. I'm noting that counsel, Mr. Larry Hanfield, will be of record as well.
Yes, Your Honor. He's just out of the country on a pre-planned vacation, so
Okay.
he asked me to stand in when he
Not-
found out.
Not a problem. As soon as we get Mr. Leo, we'll go ahead. Just, the state has filed a motion for pretrial detention.
I haven't seen that.
You haven't seen it? You haven't seen it? Can we hand counsel a copy? He should have a copy. Is there any way we can give him a copy, please?
We thought that for Judge, but I do believe that we can hand this.
Please. So that he has a moment to review it. Can I have a quarter on this? Or it's back here. No, it should be here. It should be here, sorry.
So what you just adding the
Yes.
page number of section? That's it.
Huh?
It looks exactly like this.
Yes,
Exactly.
And what's the other one?
Okay. All right, thank you.
Okay, it's here. Okay, all right. Yeah, I'm gonna start once I get this. Yeah, okay, all right. I know. Can I please have Mr. Leo Gilbert be brought?
They're going to grab him now, Judge.
I appreciate it. Thank you. Thank you for letting us know.
And right there.
Good morning, Mr. Gilbert.
Good morning.
Case number F-255863. You're here because your attorney is here before the court. I'm going to allow him to make his appearance so that you can hear that he's here. Go ahead, counsel.
Thank you, Your Honor. Good morning, Mr. Gilbert. My name is Attorney Arthur Jones. I work with Larry Hanfield. As you may be aware, he's out of the country, so he asked me to stand in for him, and that's what I'm doing.
Mr. Gilbert, and he's here in person for the record. You're charged with 1 count of trafficking fentanyl, 14 grams, it says, 181 pills, 17.70 grams, first-degree felony. You're also here because you're charged with 1 count of cocaine possession, third-degree felony, cannabis possession with intent to sell, manufacture, or deliver, third-degree felony. At this time, I have here before the court motion for pretrial detention for the first count. Is that correct, State?
Yes, Judge.
Okay. You want to go ahead and argue
Yes,
your motion?
Judge, we are asking for pretrial detention in this case, given the nature of the one that is being trafficked. In addition, and the amount, Judge. In addition, the defendant does have multiple prior arrests or drug-related charges. It began with charges around the college campus, and now it has risen to the level of fentanyl, Judge, as well as many narcotic equipment, drugs, and use. We do believe it poses a danger to the community, given the nature of fentanyl as being such a dangerous drug. We are asking for pretrial detention.
Counsel will hear from you.
Thank you, Your Honor. So first, we're asking that you deny that motion on several grounds. So I'll begin with the priors. We heard drug-related arrests. I didn't hear about any convictions. Number one. Number two, the motion, they are checking the box for filing the motion, which is a requirement. But the motion that I have is the only difference between your copy and mine is that yours, they would have written in the name here, but the substance of this motion, it's a boilerplate motion, just like the pre-written DUI arrest forms at a DUI checkpoint. There's nothing in particular here about this client, about this particular defendant. Under the statute, they have to show by this particular, not just the charges, the nature of the charge, but why this particular person is a substantial flight risk and a danger to the community. That is not what they have shown, not in their motion or their argument. They're relying simply on nothing more than on the charge of fentanyl, which qualifies. It's not based on the amount. He's looking at him in man, but it's a first degree felony. It's not a life amount because it's less than 28 grams. So that's a significant point. But also his particular circumstances have to be taken into account. And his particular circumstances, based on their rendition of his priors, he has no prior convictions, and this gentleman is 37 years old. Furthermore, if based on the arrest form itself, this is a number of drugs that are allegedly found in his room in last July, right? What happens is they find out they're executing an arrest warrant. He does get arrested and he's on federal pretrial release, so he is being supervised. As far as him being a danger to the community or flight risk, that's also important because he has this, the arrest form dates this activity back to last July. And again, he was arrested then and has a federal case, but he's been out. What happens is, if you look at the last page of the arrest form, it says on February 7th is when they get the results of this year of 2025, is when they get the results that this is indeed fentanyl, according to the allegations. Then yesterday is when they decide to make the arrest. And if there was any problems with the arrest, they would have noted it in this arrest form. The omission means that he was arrested without intent. So he's not a flight risk. He's already under supervision with the federal pretrial detention. And they have shown nothing other than just the charge to claim under the pretrial detention statute that he is a substantial risk of not returning back to court. So we actually deny the motion and then issue a standard bond.
Okay. All right. Any response, Dave?
Yes, Judge. First, the defendant has multiple prior arrests in Gainesville. He does pose a flight risk given that he possibly can go somewhere else and does have family or friends given that he lived there. Additionally, Judge, we see from the arrest form for corners that the defendant did have multiple weapons in his bedroom, in addition to other drugs that were found. We do believe for that reason that his pretrial detention should be done.
All right.
One last thing about the Gainesville thing. They said on a college campus. This is why I point out this man is 37 years old. He's clearly not in college. He's from Miami Gardens. He's been here the whole time. They've been able to find him and execute warrants whenever they want. He has ties to the community.
Okay. All right. At this time, the court is going to grant the motion for pretrial detention as to count one, and he will be held no bond. Sir, your attorney has made very good arguments. Those arguments will be presented to the division judge more likely than not on Monday. So you will see a judge on Monday. So for count one, the court will grant the order, as I said, for pretrial detention pursuant to Florida statute 907.0515D on the grounds indicated in the order. And no bond count one. As to counts 2 and 3, it will be $2,500 each count. Again, you'll see the judge on Monday. Attorney more likely than not will be there. Those arguments can be made before the division judge. I'm going by the limited information that I have. Thank you, counsel.
Understood, Your Honor.
Thank you. Next, the case of Carla Elvira Dominguez Ruiz at 255893.
Your Honor.
Yes.
She was given pretrial alternate 150 on her traffic.
Present before the court,
Okay.
Judge.
All right. Good morning. Good morning, Ms. Carla Elvira Dominguez Ruiz. This is F-255893. You're charged with 1 count of fentanyl, selling, delivering, possessing, with intent, first-degree felony, second-degree felony, transportation of drug paraphernalia, cocaine possession, crack cocaine residue, third-degree felony, and second-degree misdemeanor prescription of or new drug possession without prescription.
Judge, the defense would like to be heard on probable cause in this case.
I'm sorry?
The defense would like to be heard on probable cause in this case.
For which count? Because I'm going to read the A form now.
Count 1 and count 4.
Give me 1 minute. Okay, go ahead, counsel, make your argument.
So Judge, as it relates to count one, she was arrested for possession of fentanyl with the intent to sell. There's no indication in this arrest affidavit that she had any intent to sell. There's no indication that she had any cash on her. There's no indication that, there's a large trafficking amount of fentanyl that would be consistent with sales. The allegations in the arrest affidavit are consistent for personal use, and there's no indication of any fact in this arrest affidavit that would show she was selling or had the intent to sell. So there is probable cause for a third-degree felony possession of fentanyl. I believe the total amount of fentanyl was 0.7 grams, which is not consistent with selling or not consistent with the intent to sell. So there's no probable cause for possession with intent, just simple possession. As to count 4, there's no prescription drug that was found during the search, according to the arrest affidavit. Count 4 is for a situation where somebody has an actual prescription drug without a prescription. The facts of the arrest affidavit say that there's powdered white powder found in various bags, found in aluminum foil. That is not consistent with these being prescribed or prescription type drugs without a prescription, Judge. So the defense would be seeking an ROR on, well, not an ROR on count 1, but standard bond on count 1 for simple possession rather than first degree felony, and then an ROR on count 4.
Let me hear from the state.
Yes, Judge, this is a probable cause argument. I'm sorry, it's really hard to hear the defense. I don't know if we could ask them to
If you can speak into a microphone as much as you can, I know you will have to kind of just.
But
is there anything that the court wasn't able to hear that needs to be repeated?
I didn't hear, Judge. It was just hard to hear. So if any more arguments are made,
that's fine. Go ahead.
Thank you. Judge, we do have to look at the totality of the circumstances in this case. Given the fact that the officer found that there were 7 bags containing fentanyl residue and that they were all packaged in 7 separate bags, and totality of the other H49 labels with broken glass pipes or different pills, the officer can use those facts to find probable cause and do not have to prove beyond a reasonable burden. It's just a very simple, reasonable officer will find in this case, and we do believe that there's probable cause.
Anything else, counsel?
Yes, Judge, just as far as the state's argument that there were bags found with residue, that is consistent with personal use. That is inconsistent with the intent to sell. And again, the total amount of fentanyl found during this search was 0.7 grams, which is not consistent with selling or having the intent to sell. And the fact that there was also paraphernalia found during the search is also consistent with personal use rather than intent to sell. So there's no probable cause that Ms. Dominguez-Ruiz had the intent to sell or was selling. There's just probable cause for simple possession for personal use, Judge.
There was a scale that was in a cardboard box in the trunk. We believe that this could be used for measuring the weight of those.
All right, counsel, there's a pretrial pretrial detention motion that has been filed and just handed to me. I don't know if you have a copy.
I do not have a copy, Judge, but again, this is not one of the dangerous crimes that's listed in subsection 5A. Possession of fentanyl with intent to sell is not a dangerous crime listed. That's an exhaustive list of dangerous crimes for which the state can seek pretrial detention, and this is not one of those, Judge, so that should be denied.
Judge, it does not have to be a specifically violent crime. It can be just certain drug trafficking offenses. Given the nature of fentanyl, it is one of those trafficking offenses that is dangerous.
Okay.
Judge, this is not a trafficking offense, Your Honor. This is possession with intent to sell. Trafficking offenses are very specific, and they're defined by possession of a specific weight of a narcotic. So in the pretrial detention statute, it does say drug trafficking for certain controlled substances. She was not arrested for drug trafficking, and there's no probable cause for drug trafficking, but because the total amount was 0.7 grams. That's not a trafficking amount, Judge. Trafficking is a term of art when used in criminal law, and there's no PC for trafficking. She was not arrested for trafficking, and the state cannot seek pretrial detention based on possession with intent to sell whenever it's not listed as a dangerous crime under the statute.
Thank you. At this time, based on the arrest affidavit, the court finds that there's probable cause in this case. With respect to the motion for pretrial detention, at this time, it's granted on the grounds indicated in the order. As to count 1, it will be held no bond. You'll see the division judge on Monday, more likely than not. Count 2, $2,500 bond. Count 3, $2,500. And count 4, $150. Bond is set. Thank you. Next. We have Dailet Uribaso Hernandez, F25 5867.
Your Honor, she refused reset for tomorrow.
Okay.
It's recent.
Refused. reset 3/23 is tomorrow. Yes. Thank you. Next we have Chaylen Hernandez Giron, F-25 5869. Ms. Hernandez Giron. Good morning, ma'am. You're here today because you're charged with one count of cocaine possession. It says selling, delivering, possessing with intent in a college or university, first-degree felony. You're also charged with unlawfully using a communications device, third-degree felony. Tampering with physical evidence is count 3, third-degree felony, and controlled substance with intent to, it says, with intent to sell, deliver, possession, a second-degree felony, and that's as far as it says cocaine. Those are the 4 charges. So at this time, let me read the A form. Give me 1 minute. Counsel, if you have any arguments, you can make them at this time.
Not as it relates to probable cause, Judge, but Ms. Hernandez has 1 previous withhold. She has no other prior convictions. She has 1 previous arrest other than that withhold of adjudication for a case that was dismissed. The defense is requesting pretrial services.
Okay, so at this time, the court finds there's probable cause. Your attorney is there to represent you, ma'am. And the state has filed a motion for pretrial detention. Let me hear from the state.
Yes, Your Honor. The defendant in this case is charged with 6 counts. One of those is a first-degree felony, possession of.
Yeah, give me 1 second. Let me repeat it back to you. I just realized that, ma'am. Let me repeat it back to you. My apologies. You're charged with 3 counts of a first-degree felony, cocaine possession, selling with intent at a college or university. 3 counts of unlawfully using a communication device, third-degree felony. 1 count of tampering with physical evidence, third-degree felony, and 1 count of controlled substance cocaine, second-degree felony. Go ahead. And they have filed a pretrial motion on the first 3 counts of cocaine. Is that correct?
Yes, Your Honor. Specifically, as it relates to this charge, the defendant is charged with possession with intent to sell on a college or university campus. We believe that this is a risk to the community, specifically being that it is a school, a college university setting, and that the trafficking but the sale and distribution of these drugs on those campuses poses a risk and a danger to the community. It is a first-degree felony. We'll be asking for pretrial detention.
I'm sorry, you'll be asked
For pretrial detention.
on which counts you said?
Yes, Your Honor. That would be on the on count 1, the cocaine.
The first 3 counts.
Yes, Your Honor.
And any others, or that's it? That's it? Okay.
That's it, ma'am.
All right. Counsel, we'll hear from you, your argument.
So, Judge, again, this is not a dangerous crime. This is not a trafficking offense. The Florida pretrial detention statute, and I'll cite that statute, 907.051, subsection 5A, lists dangerous crimes. Sale of a controlled substance is not a dangerous crime. The state is moving for pretrial detention based on a threat to the community, which requires a probable cause finding that the defendant committed a dangerous crime as defined under that statute. She is not charged with a dangerous crime. There is no probable cause for a dangerous crime. This is not a trafficking case. It's a sale case. There is a difference under the law, and an order granting pretrial detention for a crime that is not a dangerous crime under the statute is illegal, Judge. The court should deny this motion because there is no dangerous crime under the statute, and she cannot be held no bond pursuant to that motion.
Okay, all right.
Your Honor, may I respond?
May you respond?
The statute where it speaks on the legislative intent says that it's the policy of the state that persons committing serious criminal offenses posing a threat to the safety of the community and integrity of the judicial process. That is not to say that it is necessarily supposed to be a dangerous in the sense of a violent crime, but it is a danger and a threat to the community.
Yeah, so additionally, it also has to do with whether the defendant has been convicted for any other crimes. And when we're considering felonies, loopholes do count as convictions, excuse me. And in this case, the defendant does have multiple arrests for selling hallucinogenics as well as possessing controlled substances without prescription as well.
Judge, the statute says to hold her on pretrial detention, she has to presently be charged with a dangerous crime. This is not a dangerous crime. The state has not cited to any portion of the statute that says that you can hold someone in pretrial detention for a crime that does not qualify as a dangerous crime. They cite to the section of the statute that discusses legislative intent, but the legislative intent is then discussed in all the other sections of the statute. And it says, if you are presently charged with a dangerous crime and other factors exist indicating that they are a threat to the community, the court can grant a motion for pretrial detention. But the statute defines dangerous crimes. Drug sale is not a dangerous crime under the statute, and this motion has to be denied. If the state can point to a portion of this statute that applies to this case, then I'll look at it. But there's nothing in this statute that says she can be held no bond based on a crime that's not a dangerous crime, Judge.
Thank you, counsel. At this time, the motion for pretrial detention is hereby granted on the grounds indicated in the order as to counts 1, 2, and 3. Defendant will be held no bond pending seeing the division judge. More likely than not on Monday, counts 4, 5, 6, and 7 will be $2,500 each. And state, we still have, in defense, we still have 8, 9, and 10 to be set. We'll do $2,500 on each.
Yes, Your Honor.
Okay, all right, thank you.
Your Honor, it's 2,500 on counts 4 through 10, correct?
Correct. 1, 2, and 3 held no bond. Thank you.
Thank
you. Next case, we have Tiara Michelle Carter, F255882.
Carter is present before the court, Judge.
Ms. Carter, good morning, ma'am. You're charged with 1 count of battery to police officer, corrections, firefighter, or transit officer. It's a 3rd-degree felony, and 1 count of resisting violence. Resisting officer without violence to his person.
Judge, I would like to be heard on probable cause in this case.
Go ahead, reading the A form. Go ahead, you may proceed.
So, Judge, as far as this arrest affidavit goes, it just begins by the officer saying they were conducting an investigation and then begins to make the allegations of battery and resisting. Both of those charges require an essential element is that the officer was acting under the lawful performance of a legal duty. If an officer is investigating or has detained someone without probable cause or without reasonable suspicion, there's no probable cause for battery on a law enforcement officer or for resisting, because an essential element is not present and probable cause for an essential element is not listed. There's no information in this arrest affidavit indicating why the officers initially had Ms. Carter detained. There's no information that they were lawfully executing a legal duty. And without that, there cannot be any probable cause for battery on a law enforcement officer or for resisting arrest, because there's no probable cause as to an essential element of each of those crimes, Judge.
Counsel.
Yes, Your Honor. So the arrest form indicates that officers were conducting an investigation for a separate incident involving both defendants inside of the jet bridge feet away from the aircraft. Additionally, I believe counsel argued that there was it's for the resisting, the element that was missing was the resisting. Is that what he said?
The thing is, we can barely hear sometimes.
I'm so sorry. No, for both of the charges in the arrest affidavit, there's an element that requires that the officers be lawfully executing a legal duty. The statement that they're conducting investigation does not establish probable cause that they were lawfully executing a legal duty, because if you are unlawfully detaining someone, unlawfully arresting someone, that is not the lawful execution of a legal duty. So there's no probable cause based on the allegations in this arrest affidavit that the officers were lawfully doing their duty. And without that, there cannot be probable cause for either of these charges, because that's an essential element for both.
Yes, Your Honor. So the defendant the officers are conducting an investigation, having conversation with the defendant in this case, where
Judge, yes, this occurred at Miami International Airport, and it appears that the current co-defendant were in the jet bridge feed of an aircraft. This poses even possibly a national security officer who have more leeway to conduct investigations at the airport, and for that reason, there is probable cause.
All right, counsel, at this time, I find that there's probable cause, given the information in the arrest affidavit. First, you can argue and make any arguments before the division judge. Now, with respect to the 2 counts, it says that count 1 is to the battery and a law enforcement officer or other is to be set.
Judge, we would be okay with the standard bond of $5,000 on the battery charge, and for the resisting without violence charge, Judge, if you just give me a moment, we would also be okay with the standard bond.
500 is the standard bond.
Yes.
Okay, counsel, any arguments on that?
Yes, Judge. So Ms. Carter has no local priors. I understand that she is from out of state, but it's my understanding that she's never been arrested in her life. And I believe if she had, I think the state would have a copy of Ms. Carter's NCICs, being that they did not cite any NCICs. I believe that I'm correct in assuming that she has never been arrested in her life. The issue with standard bond, Judge, is people from out of town have a very difficult time finding a bondsman who will post the bond in the standard practice of the defendant paying 10% and then the bondsman posting the rest of it. If you're from out of state, most bondsmen will not do that. So the defense is requesting that the court issue a bond that is 10% of the standard bond so that Ms. Carter will be able to post the entire amount and isn't deprived of what somebody would be, able to avail themselves of if they're from Florida, to give her a bond in the full amount without knowing that she's going to have a difficult time finding a bondsman, just sort of would hold her in custody because she's not a local in Florida, and issuing bond at an amount that she could actually post would be ensuring her right to a pretrial release under the Florida Constitution, Judge.
Yes, but 10% of that amount would be even less than for a misdemeanor, right? Yeah, it would be 500, and even a misdemeanor is 1,000, so would it even be less? What is the state's position given counsel's argument?
yes, Your Honor, the state would still be asking for standard bond. As counsel note, she's from out of town, so allowing her to post the bond she poses a flight risk of not returning without a bond.
At this time,
Judge, if I could I be heard, Judge?
sure.
So as to her posing a flight risk, I mean, first of all, if she doesn't appear to court, there's going to be an AC issued and she will be arrested. She has never been arrested before. She has never indicated that she would be a flight risk. Being that she's from out of town, in and of itself doesn't indicate that she's a risk of not returning to court. All that would do, her being out of town, if the court issues a standard bond, she's not able to post it. She's just going to be held in a jail that is in a county that she's not from. She has no family here. She has no friends here. She'd be held in a foreign jurisdiction. That would be essentially cruel and unusual, Judge. If the court,
Judge, and they can make a different determination. If that is the case, I'm sure if she doesn't post bond, she'll go before the division judge. So at this time, the court will set bond for count 1 in the amount of 5,000 and count 2, 500.
would the court be inclined to at least reduce the bond amounts to 1,000 on count 1 and 500 on count 2 to give her a chance of posting that, Judge? She's never been arrested before in her life.
We'll do 1,000 and count 1. That's fine. I'll change that, counsel. I'll be 1,000, count 1, 500, count 2. State, if you have any objection, you can put it on the record. But
Yes, Your Honor, state would object.
all right. George Edward Emmanuel, F-25 5879.
State has a stay away order for that.
Okay. All right.
Judge Emmanuel refused. Reset for tomorrow.
All right. All right. So refused, reset, 323. Next, we have Patrick Gaines. Oh no, this is not Gaines. I'm sorry. Patrick Gaines,
Present before the court, Judge.
F-25-5883. Mr. Gaines, good morning. You're charged with one count of robbery with an armed weapon, first-degree felony, and aggravated assault with a deadly weapon, third-degree felony. And Mr. Gaines, the last count that I read, the aggravated assault with a deadly weapon, is 3 counts of that, third-degree felonies, and 1 count of an armed weapon, robbery, first-degree felony. State.
Yes, Judge, the normal standard bond for a robbery is $10,000, Judge, given that, one moment, Judge. So we did order, have an order for pretrial release on this case, Judge. It's because of the nature of the crimes. There's,
Pretrial release or pretrial detention?
I'm sorry, pretrial detention, Judge. There are 2 counts of assault with an aggravated weapon, as well as robbery, which is also with a weapon. These counts are all individually dangerous crimes, but also in the aggregate, given the amount of the crimes, we would be asking that no bond.
Okay, at this time, the court finds there's probable cause. Your attorney is there to represent you, sir. And let me hear counsel's argument with respect to the motion for pretrial detention.
So, Judge, while this is
Thank you. Go ahead, counsel.
So, Judge, while this does technically fall under the definition of a dangerous crime, there's nothing else that would indicate that he's a danger to the community or a flight risk. He's homeless, Judge. The defense would be requesting for TAP and requesting that Your Honor deny the motion for pretrial detention.
Thank you. As far as a motion for pretrial detention, it is hereby granted. The order is entered as to count 1. He'll be held no bond. You'll see the division judge. Counts 2, 3, and 4, 5,000 each. Thank you. And sir, before you go, let me read to you the stay away order. Can I get a copy?
Yes, ma'am.
Sir, I'm issuing a stay away order. Can I please address counsel? Can I please address your client for a minute?
Yes, Judge.
Mr. Gaines, I'm issuing a stay away order, sir. You have to stay at least 500 feet away from 2000 Collins Avenue in the city of Miami Beach. Do you understand that? Do you understand that? Did you hear me?
And Judge, in addition, the victims in this case, we can state.
I ain't do shit.
Can I please have a stay away order? Sir, I'm gonna read a stay away order to you. It's very important that you listen carefully, because if you violate, you can face jail. Can I have the audio on for him, please? Okay, he's arguing with his attorney. Corrections is in front, and appears that he's arguing. Sir, I'm issuing a stay away order. You have to stay 500 feet away from Mayra Celis, Ronald Lopez, and Daniel Rodriguez, and the address at 2000 Collins Avenue. There are now 4 corrections officers in front of you. The stay away order has been issued. Failure to abide by that can result in jail if you're found guilty.
I couldn't hear what she was saying because I was walking in.
Okay, then I can go ahead and explain it to you again, sir. I don't mind repeating myself. Mr. Gaines, can we proceed with the hearing at this time, sir?
Yeah.
Give me a minute so you can go about your way. Mr. Gaines, did you hear the charges, sir?
I couldn't hear.
Mr. Gaines, why don't you let me do the talking for a minute, okay? Let's do that. You're gonna see another judge anyways. I'm just here for today, okay? I will not be the judge in your division. Another judge will have an opportunity to make other arguments in front of that judge, okay? Okay, Mr. Gaines, I'm issuing a stay away order. You have to stay 500 feet away from 2000 Collins Avenue, Miami Beach. Can somebody turn on the audio to see if you understood that?
Yeah.
Thank you. You also have to stay at least 500 feet away from Mayra Celis, Ronald Lopez, and Daniel Rodriguez. All contact is prohibited, third party, directly, indirectly, and through social media or electronic contact. Do you understand that as well?
I don't even know them. Yes.
Okay, thank you. Let's call the next case. The next case is Jonathan Chacon, F-25-5884. Is this, oh, it's a PV, so the felony, okay. Got it. Mr. Chacon, good morning. Mr. oh, actually, good afternoon. Mr. Chacon, You are charged with 1 count of battery, domestic violence by strangulation. It's a 3rd-degree felony. 1 count of tampering with a victim or witness, 3rd-degree, it says 2nd-degree felony. And false imprisonment, 3rd-degree felony, and 1 count of battery, 1st-degree misdemeanor. At this time, sir, the court finds that there's probable cause in this case. Your attorney is there to represent you. I'm issuing a stay away order, Mr. Chacon. You have to stay away from the person whose initials are JB. You're prohibited from having any contact with this person directly, indirectly, through third parties, telephone, social media, electronic contact. You have to stay away from that person at least 500 feet. Do you understand that?
Yes, Your Honor.
Okay, I heard yes, ma'am. You cannot have any possession, you cannot possess, purchase, or use any weapons, ammunition, or firearms. If you have any, you have to surrender them to the nearest police department and file a receipt with the clerk of court. Do you understand that as well?
Yes, ma'am.
Thank you. Do you need to go back to this place? Is there anything he needs to do that I need to assist him with? It says,
No, ma'am. That apartment we were renting together, but I can go back to the apartment that I have on my license with my mom.
so that would be not applicable at this time. You don't have to return. Now, stay away order has been entered with respect to bond in this case.
And Judge, I apologize. There was a bit of a misunderstanding. Mr. Chacon does not intend to reside there, obviously, but he believed that is what the court was asking. He does say he has some personal property there he would like to retrieve.
That's basically my concern, so we can assist him with that. Sir, at this time, you'll be allowed, once you're released from custody, 1 time to go to this residence, the alleged victim's residence, within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal belongings. 1 time with a police officer, okay? So that you can get your personal belongings in the form of medication, tools, paperwork, and clothing. All right, so I'll allow that.
Thank you, ma'am.
And with respect to Mr. Chacon's bond, state.
Yes, Judge, the state, also particular, has a 2010 leading to an accident, however, given, that the victim was responsive with a on 1 and the state held against, her will, the state would be asking for an elevated bond on the first count of, $15,000. And on the second count, the state would, be okay with standard bond. Standard bond for tampering with witness is $7,500. A standard bond for false imprisonment is $1,000. And 1 moment for the battery bond. 1,000.
Judge, I apologize.
Yes, counsel, go ahead.
I wasn't able to hear either the state's argument. I heard that they were requesting an elevated bond.
They mentioned amounts as to count 1, they mentioned 15,000, and then from counts 2, 3, and 4, they mentioned standard bond. They would request standard bond.
And did they mention any priors?
Yes, we did the 2010 leaving scene of an accident. In addition, we also mentioned facts alleging the arrest forms, which is unresponsiveness, and something we forgot to tell the judge, but we would like to make them aware now, is that there were minors who were possibly present at this location, Judge, which is why on the first bond, we are requesting an elevated bond.
So, Judge, as it relates to the priors, it seems like the only prior he has, and it's not even from Miami-Dade County, because the prior list that I have shows no previous arrests, no previous cases in Miami-Dade County. It sounds like they're listing a leaving the scene of an accident from 2010, which is over 15 years at this point. He hasn't been arrested. He hasn't had any contact with the criminal justice system between 2010 and this case. A elevated bond would be excessive. Mr. Chacon would not be able to post that bond, Judge. You know, he is presumed innocent. I understand the allegations in the arrest affidavit are serious, but being that he has been arrest-free for over 15 years, that these are all third-degree felony, second-degree felony for taking the phone, Judge, the defense would request that the court issue standard bond, $2,500 or $5,000 on count 1, $2,500 count 2, and $1,000. Oh, excuse me. 2,500 on count 3, and then 1,000 on count 4. If the court is not inclined to give those bond amounts, the defense would request that the court grant house arrest with no monetary bond. Mr. Chacon has work. He needs to be able to provide for himself. He needs to be able to make a living. And if the court grants the elevated bond, he will not be able to post it, and he'll be held in custody simply because he does not have the financial resources to pay that amount. A GPS monitor with no monetary component would ensure his presence at all future hearings. It would alleviate the concerns that the state might have for the protection of the alleged victim, and it would actually do those two things better than a monetary amount would. If Mr. Chacon was a wealthy person who could afford that bond, he would be able to post those elevated amounts, get out of custody, and there would be no other measures to ensure that he complies with the stay away order or arrives at his future hearing dates. So if the court is not inclined to grant the monetary bond requested by the defense, we request that Your Honor just put him on a GPS monitor so that he's not held in custody just because of his lack of financial resources.
Judge, just to correct regarding the allegations of the defendant not having any prior run of the law in the last 15 years, the defendant was arrested for battery in 2024. He has been convicted for battery twice in Columbia, County of Columbia. He also has a aggravated battery with a weapon previous arrest, in addition to probation violations as well, Judge. And actually, I feel like he's also been charged with the third offense, battery. So we do believe that he does pose a great risk to the community given the amount of battery charges, Judge. But this,
Judge, I don't have those, first of all, Judge. And second of all, I noticed that the state didn't mention anything about the dispositions on those cases. So to the extent that they were dismissals or no actions,
they said conviction on a battery.
Yes.
And two other batteries out of the county, but one here in Miami-Dade County is what I heard.
No, I stated, excuse me if I misspoke, that in the County of Columbia, he has a second conviction battery, and then he was also charged with the third battery. I'm not sure what the disposition of that one was.
And how long ago were those?
2016, 2024 was the last one that he was charged with in Columbia from June 14.
Okay.
And was that dismissed in 2024?
I don't have the disposition of that, but that was the last arrest that I see here.
This is what the court is going to do. Count 1, 7,500. Count 2, 7,500. Count 3, 2,500. Count 4, $1,000 plus GPS level 2.
Judge, if the court's going to put a GPS monitor on, why is the court granting a monetary bond in the amount that he cannot afford? He will not be able to post that, Judge. A house arrest monitor, which Your Honor has already imposed, is more than sufficient to take care of any concerns the state may have and ensure his presence. At this point, he's just going to be held in custody because he's not a wealthy man, Judge.
Hey, do you have any objection that it be done as an alternate bond, house arrest? Level 2, alternate bond, the bond that the court indicated.
So our concern is that the defendant may live with the victims.
Okay, and if they're very serious charges, counsel, I will leave it as is at this time. Please file the appropriate motion before the division judge. But your argument is noted, counsel. Thank you. And after reconsidering, it's respectfully denied. It's going to be plus GPS. Jose Juan Prudencio Diaz, F25 5885.
Your Honor, he has a hold for immigration.
Okay, all right. Thank you for letting me know. Immigration detainer noted. No, but yeah, I'm sorry, you filed a motion, but let counsel finish with his client. And then.
Mr. Prudencio Diaz is present before the court, Judge. He does require the services of a Spanish interpreter.
Mr. Prudencio Diaz, good afternoon. The interpreter is present.
Buenas tardes, señor Prudencia Díaz.
This is case number F25 5885.
Estamos aquí en cuanto al caso F25 5884.
Okay, give me 1 second.
Denme un momento.
Yes, Your Honor.
All right, sir, at this time, you are charged with the following.
Bien, en este momento, señor, se le imputan los siguientes cargos.
One count of lewd and lascivious conduct, molestation on child 12 to 16 years, second degree felony.
Un cargo de abuso deshonesto con un menor de edad de entre 12 y 16 años de edad.
One count of a second degree felony, lewd and lascivious exhibition on a child 16 years or less.
Un cargo de abuso deshonesto, exhibición indebida con un menor de edad de menos de 16 años o menos.
One count of HIV infected, sex with another, uninformed, without informing, third degree felony.
Un cargo de contagiar a una persona sin conocimiento con VIH, un delito grave tercer grado.
And at this time, sir, your attorney is here to represent you. There's probable cause in this case. I'm also entering a stay away order in favor of the alleged victim by initials JH. You have to stay at least 500 feet away from this person, their home, their school, their place of employment at all times. All contact in person through third parties, electronic contact and social media. All contact is prohibited. Stay away order is entered. Please understand that.
En este momento se determina que existe motivo fundado para justificar estos tres cargos y además de eso se dicta una orden de alejamiento con la presunta víctima cuyos iniciales son JH. Además, con dicha orden queda prohibido acercarse a menos de 500 pies de la víctima donde esté ella, en la escuela, en el lugar de trabajo, donde sea, le queda prohibido contactar con ella de manera alguna, que sea de manera directa, indirecta, por internet, por mensaje de texto, como sea, toda comunicación queda prohibido.
Please let me know if you understand that.
Dígame si ha entendido.
Sí.
Yes.
Okay. And with respect to bond counsel, I have received a motion for pretrial detention.
Y letrado, en cuanto a la fianza, me han entregado un escrito pidiendo prisión preventiva.
As to what counts is this?
En cuanto a qué cargo.
Your Honor, that would be to the first three counts. So
First three or the first two? First two. Okay. All right.
We filed a motion for pretrial detention.
Can you speak a little bit into the microphone? I want to make
Yes.
sure council can hear you.
Yes, Your Honor. Given the severity of the accusations in this arrest form, the state has asked for pretrial detention. We believe that this defendant poses a threat to the community. This is a 14-year-old victim of a sexually motivated crime. It falls under the statute as a dangerous offense. Additionally, as has already been noted, there's an immigration hold, and I do not see any previous arrests. However, the defendant is a citizen of Mexico, so I do not know if he's ever been arrested or been convicted of any crimes in Mexico. Yeah.
Señoría, pedimos prisión preventiva en cuanto a los primeros dos cargos por la gravedad de estas acusaciones. La víctima es menor de edad de 14 años, en este caso de un delito de naturaleza sexual. Por lo tanto, nosotros consideramos que él constituye un peligro a la comunidad si fuera a salir, y bajo el estatuto eso se considera un delito peligroso, y además tiene una retención migratoria, le pusieron esa retención. También no veo que lo han detenido antes por delitos previos, sin embargo es de nacionalidad mexicana y no sabemos si en México le han detenido por delitos de esta naturaleza.
Counsel? Any
Yes, Judge.
comments?
Defense objects. He already has an ICE hold. The pretrial detention is unnecessary. Defense has no objection to standard bond.
La defensa se opone ya que depusieron la retención migratoria. Nos parece innecesario pedir prisión preventiva. Pedimos la fianza ordinaria.
Yes, Judge, we asked that he be held no bond. We understand that he does have an immigration hold. However, he does go through the immigration process. It is more difficult to ensure that he will be here and be brought to trial. Defendant in this case is acting in concert with another defendant. They were both on a cruise. This shows that they tried to target a specific minor, and this could be done again. It is one of the dangerous crimes, and we strongly would request that the court hold this defendant no bond.
May you please, that it was a cruise and there's a co-defendant. May you please repeat that?
You said it correctly. You heard correctly.
Okay.
Do you
So
need
there, a pesar de la retención migratoria, la Fiscalía pide prisión preventiva en la causa y de todos modos, igual lo que vaya a pasar a él con la situación migratoria, lo vamos a enjuiciar aquí por este delito. Además, el delito se cometió en un crucero con un coacusado y ellos escogieron a la menor de edad en cuestión y esto es un delito peligroso.
Okay, at this time, with respect to the motion for pretrial detention, the court is hereby granting the motion for pretrial detention based on the grounds indicated in the order. The order is being entered, and as to counts 1 and 2, defendant shall be held no bond. As to count 3 will be $2,500 bond. And yes, I've noted an immigration detainer in the file.
En este momento, la petición de la Fiscalía de imponer prisión preventiva se concede por las bases sentadas en el escrito en el primer y el segundo cargo, y en el tercer cargo la fianza será de 2,500 y ya, como señalé, ya le pusieron una retención migratoria.
Your on count 3 is 2,500 or 7,500?
2,500.
Thank you.
2,500 en el
Counts 1 and
tercer
2, no
cargo.
bond.
Y prisión
case.
preventiva en los dos
Ricardo
primeros
Daniel Mondragón Leal, F-25 5886.
Present before the court, Judge. He also requires the services of a Spanish interpreter.
Your Honor, he also has a hold for immigration.
All right, sir. Thank you. Good morning, good afternoon. Immigration detainer is noted for the record.
Buenas tardes, señor, y cabe señalar para el acta que le han puesto una retención migratoria.
Mr. Ricardo Daniel Mondragón Leal, in this case, you're charged with the following.
Señor Leal, en esta causa se le acusa de lo siguiente.
1 count of, it says, of sexual battery with circumstances for a minor, and this is after October 1st, 2014, first-degree felony.
October 20.
October 1st, 2014.
En este caso, señor, se le acusa de agresión sexual en cuanto a un menor de edad y eso ocurrido el día 1 de octubre de 2014.
You're also charged, it says, molestation on child 12 to 16 years, lewd and lascivious conduct, second-degree felony. 1 count.
Además, se le imputa un cargo de abuso deshonesto de un menor de edad de hasta 16 años de edad, un delito grave de segundo grado.
Lewd and lascivious exhibition on a child less than 16 years of age, second-degree felony.
Abuso deshonesto, exhibición indecente con un menor de edad de menos de 16 años, un delito grave de segundo grado.
I'm appointing your attorney at this time. There's probable cause in this case. I'm issuing a stay-away order. You have to stay away from a alleged victim by the initials of JH, at least 500 feet away from them, their home, their place of employment, and school at all times. All contact is prohibited. That includes in person, through third parties, directly, indirectly, electronic contact and social media. All contact is prohibited. Please let me know if you understand that.
Señor, se ha determinado que existe motivo fundado para justificar estos cargos y le queda designado un abogado de oficio. Además, en ese momento se dicta orden de alejamiento con la víctima, cuyos iniciales son JH le queda prohibido acercarse a menos de 500 pies de la víctima en todo momento donde esté ella, en el colegio, en un centro educativo, en un lugar de trabajo, residencia. Además, le queda prohibido comunicarse con ella de manera alguna, que sea de manera directa, indirecta, por teléfono, por mensaje de texto, en las redes sociales. La comunicación le queda absolutamente prohibida con la persona en cuestión. ¿Quedó claro, señor?
Sí.
Yes.
Okay, all right. At this time, I have received a motion for pretrial detention. Counsel for the state.
Yes, Your Honor. This is the co-defendant from the previous case. This is the sexual battery that occurred on the Royal Caribbean cruise ship. This defendant is also a Mexican citizen, so I do not have any priors from the United States. However, I can't say for certain whether or not he has been arrested out of the country. This is the charges that this defendant is facing is sexual battery, lewd lascivious molestation on a child, and lewd and lascivious exhibition on a child. These are dangerous crimes. They pose a danger to the community. The accusations in this arrest form are quite serious. We'll be asking for pretrial detention.
Señoría, en este momento la Fiscalía pide prisión preventiva. Él es el coacusado en el caso previo. Se trata del caso de agresión sexual que pasó en el crucero de Royal Caribbean. Él es de nacionalidad mexicana, por lo tanto desconocemos sus antecedentes ahí en México, y los delitos imputados son de agresión sexual, abuso deshonesto de un menor de edad, exhibición indecente con un menor de edad. Por lo tanto, nosotros consideramos que esta persona es un peligro para la comunidad.
The defense objects to the pretrial detention motion. He already has an ICE hold and pretrial detention is unnecessary. The defense has no objection to standard bond.
La defensa se opone a la imposición de prisión preventiva, ya que le han puesto esa retención migratoria. Es innecesario que se imponga prisión preventiva. Pedimos la fianza ordinaria.
Okay, all right. So at this time, sir, the court, after hearing arguments and review of the A form and the grounds indicated in the order, the court will grant the motion for pretrial detention. The order is being entered. Count 1, 2, and 3 will be no bond as to each count. You'll see another judge, the division judge, more likely than not on Monday.
En este momento, después de conocer los argumentos de los abogados, después de haber estudiado el atestado de la policía y escuchar las bases sentadas, se concede la petición de imponer prisión preventiva en los 3 cargos. Va a comparecer ante el juez a cargo de la causa, lo más probable sea el lunes.
All right, thank you. Next case, Luis Eloy Guardado.
Mr. Guardado is present before the court, Judge.
Thank you. All right, at this time, Mr. Guardado, good morning. You're charged with 1 count of strong arm robbery with aggravated battery, first-degree felony, and 1 count of battery on a person 65 years of age or older. That's a 3rd-degree felony. The court has reviewed the A form. The court finds that there's probable cause in this case. Your attorney is there to represent you. The state has filed a motion for pretrial detention. And we'll hear from the state.
Thank you. Judge, we did file a motion for pretrial detention. This is a dangerous offense. The defendant is charged with both strong arm robbery and battery on an elderly person, 65 years or older. These are violent crimes. In addition, Judge, given the facts of the case, where the victim sustained a laceration on the back of her head and off consequence after she was pushed, we ask that the defendant be held in.
Okay, council will hear from you. And you say no bond as to count one only or both?
As to count one, Judge.
Oh, okay. And what do
So-
you suggest on two?
Judge, the standard bond for that, we would ask that it be elevated, given that it is accompanied with such dangerous crime. Judge, and the standard bond, I believe in this case,
I think it's five. Okay, is it five? 5,000. Yeah, okay.
it was
All right.
sorry, Judge.
Yeah, you're asking for elevated. Let me, Mr. Guardado, let me hear now from your attorney. Counsel, go ahead, your argument.
Yes, Judge. So while count one does qualify as a dangerous crime under the statute, there still has to be an additional finding that Mr. Guardado poses a serious threat to the community. In this case, he has no prior convictions. If you look to his local priors, he has prior arrests. The most recent prior arrest was 2018. That case was dismissed. All of his previous cases have been dismissed, previous arrests. He hasn't been arrested in approximately 7 years based on his priors. I do not believe that his prior record, he has no prior convictions, no prior withholds, has never pled guilty to a crime. I don't believe that there's any indication that he does pose a significant threat to the community. He also has 6 children. He's the sole caretaker of his 6 children. He has work. He needs to be able to work to provide for those 6 children and provide for himself, Judge. If he's held no bond, he will not be able to provide for those children, and those children are going to go without a caretaker. He also has a 6-week-old granddaughter who he also provides for and needs to be able to work, Judge. So I would request that the court use its discretion and find that although this is a dangerous crime under the statute, he does not pose a significant threat to the community, and there are factors that require him to be released in the community to care for these children.
Thank you. And Judge, just reading off the statute, a person arrested for a dangerous crime, which the defense has admitted this is a dangerous crime, may not be granted non-monetary trial release at a first appearance hearing if the court has determined that there's probable cause, which I believe that you have, Judge.
Yes, sir.
Judge, we cannot- So just pointing to what the state had said, right? They cannot be granted non-monetary pretrial release, which is pretrial services, something that is not monetary. So the court still has the discretion to give Mr. Guardado a monetary bond, and the defense is requesting that the court grant a bond in the amount of $2,500 on count 1 and $1,000 on count 2.
Your Honor, I'm sorry, Mr. Guardado.
Yes.
A civil writ of a $5,000 cash bond.
Yeah, okay, all right. Now, sir, Mr. Guardado, I'm issuing a stay away order. You have to stay at least 500 feet away from Edith Grisby. And that includes her home, her cell, her place of employment and school, all contact, including telephone, through third parties, in person, directly, indirectly, social media, electronic contact, all contact is prohibited. Do you understand that? I'm sorry?
Yes, Your Honor.
All right, thank you. At this time, the motion for pretrial detention is hereby granted. The order is being entered. The motion is granted on the grounds indicated in the order. As to count 1, there will be no bond. As to count 2, $5,000 bond. Thank you. Next case, Kenny Prentice Wiggin.
Mr. Wiggins, present before the court, Judge. I would like to be heard on probable cause for this case.
Yes, Mr. Wiggin, good morning. This is F-25-5891. You're charged with 1 count of domestic battery by strangulation, 3rd-degree felony, and 1 count of robbery by sudden snatching, 3rd-degree felony. And we'll hear from your attorney as to PC.
So, Judge, as it relates to count 1, domestic battery by strangulation, there is a requirement that there be some sort of domestic relationship. Domestic relationship means that they either reside together as if a family, share children together, or are in a romantic relationship, which is one of the requirements. In this case, if you look to the arrest affidavit, they are no longer in a romantic relationship. The arrest affidavit alleges that they ended the relationship in January. We're no longer in a dating relationship as of January. They do not reside together. There is no information on the arrest affidavit that they share children together. So under the statute, this does not qualify as a domestic relationship, and there's only probable cause for a misdemeanor battery because there is no domestic relationship, Judge.
Let me hear from the state.
Judge, in this case, Judge, we understand that there's an allegation that the relationship had ended. Judge, but we are not sure whether they live together or not. And we believe that there's probable cause in this situation, given the nature of their previous relationship or current relationship, to find that this was a domestic violence by strangulation. In addition, the phone was suddenly snatched, and that is alleged in the four corners of the complaint.
Yes, Judge, we're not moving for no probable cause on count 2, just count 1, because there's no domestic relationship and there's no indication that they reside together in the arrest affidavit, and the relationship is ended under the arrest affidavit. So as to count 1, there would only be probable cause for civil battery.
Given that they have been in a relationship and the four corners of this affidavit, the court will find probable cause. Your arguments are noted so that you can bring them up without any prejudice to the division judge, counsel. And at this time, with respect to bond for Mr. Wiggin.
Yes, Your Honor, the state would request standard bond, which would be, I believe, $5,000 on each count. He does have several prior convictions, including trespassing, resisting, grand theft, withholds, as well as prior arrests for battery. The state believes
With
that
the same person or a different person?
Your Honor.
Sir, I'm going to issue, while you look, let me let him know. I'm going to issue a stay away order. You have to stay away from Ashley Reed, at least 500 feet away from her home, her place of employment, and school at all times. In addition to that, sir, all contact is prohibited, including social media, electronic contact in person to third parties, telephone. Do you understand that?
Yes, ma'am.
Okay, if you cannot carry any weapons, ammunition, or firearms. If you do, you have to immediately surrender them to the police station and file a receipt with the court. Do you have any of your belongings at her home that you need to go back and I need to enter an order so that you can take your belongings back? Any medication, any clothing, any tools, any personal papers?
Nothing.
Okay, that does not apply. All right, the stay away order has been entered. And state, you were saying, is it with a different person or the battery conviction you mentioned?
I don't see a battery conviction on here. I see several prior battery arrests. However,
arrests. Okay.
Yes, Your Honor, I'm not able to
No, that's fine.
do it.
Okay, all right. Counsel, recommendation for bond in this case?
Yes, Judge. So as far as previous convictions, they're all nonviolent offenses. He does have previous arrests for battery, but according to the arrest affidavit, they had only been in a relationship for 5 months and then ended in January. So that would be sometime in the middle of 2024. And those battery arrests are 2022 case, 2019 case, all dismissed as well, Judge. 2013 case. So all of these charges were dismissed, and none of those have domestic violence flags next to them either. So I don't believe they're with the same victim. I don't believe that he poses a threat to the community because any conviction that he does have is for misdemeanors. I believe he has a withhold for theft crimes that are felonies, but again, that's not a danger to the community. Mr. Wiggin cannot afford any monetary bond. The defense is requesting that the court grant him house arrest with no monetary bond so that he's not held in custody just because he does not have the financial ability to post a monetary bond, Judge. The GPS monitor would be more than sufficient to ensure his presence at future hearings and alleviate any concerns the state might have for the alleged victim.
Any objection to that, to the electronic monitoring level 2, alternate bond, no bond?
Your Honor, given his priors, he has prior convictions, he has prior felonies, he has prior arrests for the same charge, we would still be asking for standard bond.
Okay. All right. At this time, the court will set bond for count 1 in the amount of $5,000. Count 2 will be $2,500 plus GPS level 2. Next case is Sammy Lee Chapman.
The defense would ask the court to reconsider. If the court is going to issue house arrest, why are we going to make a man who has no financial means pay money? If he was a wealthy man, he would be out. would the court please grant house arrest without any monetary conditions? He's gonna lose his job, his only chance at employment, and further damage his financial resources, Judge. That the monitor is more than sufficient to take care of any concerns the court or the state might have.
Okay, counsel, your argument is noted. Please bring it up to the division judge if he has not been released by then. Thank you, counsel. Your argument is noted then again without prejudice. Thank you. Sammy Lee Chapman, F 255892.
Mr. Chapman is out on felony bond, F253001.
Okay, all right. So at this time, given that Mr. Chapman is, and let me wait for Mr. Chapman. Mr. Chapman, good morning, or good afternoon, rather. Mr. Chapman, it's my understanding that you're out on felony bond, F 253001. So at this time, there will be a felony hold. And I believe that's Division 11. So there will be a felony hold on F 253001. You are charged with 1 count, excuse me, of cocaine, selling within 1,000 feet of a public housing, suspected cocaine, and tampering with physical evidence, attempt, 3rd-degree felony. I have received a motion for pretrial detention. Let me hear from the state first and then from your attorney. Before I do that, 1 second, let me read one.
And Judge, if I could just make a request, if the state could mention what section of the pretrial detention statute they are moving under, I think that would assist.
Yes, counsel, based on the pretrial detention statute, the legislative intent is anything that poses a harmful risk to the community, and it does not only have to be dangerous offenses, it can be anything that poses a harm to the community. For those
In the statute, does it say that? Can you direct me to a subsection so that I can review it, please?
a moment. Under the legislative intent section, a moment so that I can quote it.
In the motion, they cite to Florida statute 907.04158, counsel, that the offense is a dangerous crime. That's the first sentence in line 2. I don't know if you have the benefit of the motion.
I don't, Judge, but this is the same issue we've had with all the pretrial detention motions they've filed thus far. They're citing to 5A, saying that he's arrested for a dangerous crime, but this is not a dangerous crime. Only drug trafficking offenses can qualify as dangerous crimes. This is not a trafficking offense. There is no probable cause for a trafficking offense. So to the extent that the state is filing these pretrial detention motions, seeking an individual be held no bond, citing 5A, knowing that this crime is not a crime that falls under 5A, that is a bad faith filing, Judge, and I think that's an issue, and the court should deny that motion. The state should honestly withdraw it if that's the subsection that they're moving under. That's why I inquired what specific subsection they're moving under. It's the 3rd time during this calendar that they filed a pretrial detention motion saying they've been arrested for a dangerous crime when the crime is not in the statute as listed as a dangerous crime, Judge. That's an issue.
Yes, and Judge, we also have to look at the legislative intent, as you've noted. It's not. It's also for cases in where defendant has had multiple priors, similar to the ones in this situation where they pose a threat to the community, has previously violated conditions of pretrial release, or is charged with certain dangerous crimes. So the certain dangerous crimes is a way to get a judge to grant pretrial release, but it's not the only way, Judge.
Judge, the state keeps citing to the legislative intent, but is ignoring the remainder of the statute. That statute is written with the legislative intent in mind, and it codifies that legislative intent. It says if you are arrested for a dangerous crime, here's what dangerous crimes are. The court can grant a pretrial detention motion. I'll cite to the legislative intent of the Florida Constitution that says everybody's entitled to pretrial release on reasonable conditions. If the state agrees with that argument, I mean, that's in the Florida Constitution, they should be agreeing to bond on everybody so that everybody can be released. It's not just about legislative intent, Judge. You have to look to the language of the law. That's why they've been asking for elevated bonds. That's why they have been objecting when I'm asking for bonds that would actually get my clients out despite the legislative intent in the Florida Constitution. That argument's not enough. It's unlawful.
Thank you, counsel. Your arguments are noted. At this time, I'm going to find that there's probable cause. I will grant the motion for pretrial detention. The order is granted, and then it's granted based on the content of on the grounds indicated in the order. Counsel, also, I'll just remind corrections that on F-2531, there will be a felony hold for Division 11. In this case, particularly as to count 1, no bond, as to count 2, 2,500. Thank you, counsel. Your arguments are noted. And this is without prejudice. Thank you. And that will apply to every case. Marcus Nichols, F 255877, Nichols. Mr. Nichols, good afternoon. You're here today because you're charged with 1 count of indecent exposure, second or subsequent offense, 3rd-degree felony, nuisance, 2nd-degree misdemeanor, having an open container of alcohol in the city of Miami Beach in violation of their ordinance, and smoking cannabis in public property, also in violation of the ordinance of the city. And at this time, your attorney is there to represent you, standing next to you.
Judge, I would like to be heard on probable cause.
Which count, counsel? Because I'm reading the A form.
Count 1, Judge.
Okay, go ahead, you may. Go ahead.
The court's ready?
Yes, the court is ready.
So Judge, count 1 is elevated to a felony indecent exposure because it's a second or subsequent offense. That requires a previous conviction for indecent exposure. If you look to his priors, there was an arrest for indecent exposure, but that was dismissed. So there is no prior conviction. So the only probable cause as it relates to count 1 is for a misdemeanor, 1st-degree misdemeanor indecent exposure, because it doesn't have that, aggravating factor of the prior conviction, Judge.
State.
Yes, Your Honor, I'm confirming Bruce priors. Your Honor, the statute only requires a second or subsequent violation of this section. It does not require a conviction. It does not require a withhold. It is a second offense.
I'm sorry to interrupt, I'm looking at his priors. Counsel indicated it was dismissed, and I'm looking at the no plus.
Judge, the statute does say second violation, but just to remind the government, everybody is presumed innocent. So he's still presumed innocent as it relates to that dismissal. And it does require that there's a previous conviction.
Counsel for the state.
Your Honor, it says nowhere in the statute that it requires a previous conviction. It's a second offense.
All right, given that it says second offense, and I do see 1 previously listed, at this time, I'll go ahead.
Judge, if I could have 1 moment, I'm going to pull up the jury instruction because there is no law that in Florida that allows someone to be the charge to be elevated because of a previous case that was dismissed, Judge.
Counsel, I understand. At this time, I'm going to find probable cause. Please make those arguments before the division judge. This is without prejudice, and it applies to every case, given the fact that I'm hearing second offense and I am seeing his priors. So there will be probable cause as far as this court, the limited information that I have. And for Mr. Nichols Marcus, let me take a look. He's got 4 counts, and the bond will be set as follows. Standard bond, 2,500, count 1, 150, count 2, 150, count 3, 150, count 4. Thank you. Next case, Benjamin Grady, F 255864. For Mr. Grady. Mr. Grady, good morning. You're charged with 1 count of grand theft of a vehicle, 1st-degree misdemeanor, and criminal mischief, $1,000 or more, 3rd-degree felony. I have read the A form, sir, and at this time I find that there's probable cause in this case. Your attorney is there to represent you, And with respect to bond, Mr. Grady, state your recommendation, and I'll hear from counsel.
Yes, Judge, we are going to pass you an order, asking for no release, specific to pretrial detention. Given the nature of the charges, there is a grand theft as well as criminal mischief. Criminal mischief is a dangerous offense. I'm sorry, we don't accept grand theft for charges.
Yeah, that's my.
For the, I think we were looking for it on the criminal mischief.
No,
That's F3.
that's an F3, not an
Yeah.
F1. Okay, let's, with respect to bond, state,
Okay, yes, Judge.
count one.
So is an order tonight just for the purposes of the record, Judge? We did have it in our files. We do have to bring it up to the court and make the record, Judge.
Yes, respectfully denied.
Thank you,
Thank
Judge.
you.
I'm sorry,
I'll
Judge.
make a note here,
I'm-
pretrial detention as to count one, counsel respectfully denied, nothing else needs to be said on that. Let's move on to count one. What is your recommendation? State and defense, I'll hear from both.
Judge, I would like to be heard on probable cause for count one.
Go ahead.
So Judge, grand theft of a vehicle is generally a third-degree felony if you look to the statute. I see nothing in this arrest affidavit that would elevate it to a first-degree felony. There's nothing in the values. The value of the vehicle isn't even stated. If the value of the vehicle was over, I believe, $100,000, it might qualify as a first-degree felony. But this should just be probable cause for a third-degree felony grand theft vehicle, and then the defense would have no objection to standard bond.
Thank you, counsel. All right, argument is noted. State with respect to count one, what is your recommendation?
Yes, Judge, we would ask for an elevated bond. I believe the standard bond amount for grand theft vehicle first degree, we're looking for it now, Judge. I think it's 75. 75. Thank you. We would be asking Judge for at least $10,000 bond in this case. And as well as the criminal mischief judge, we would be asking for a standard bond.
All right, thank you, counsel. Any recommendation you may have?
Yes, Judge, I'm not able to hear the state very well. I'm not sure if they've mentioned anything about priors, have they?
Can you hear me now?
Yes.
All right, thank you. We did not mention anything about priors. I'm looking right now, but I do see that this person did have prior arrest for impersonating. Sorry, I can't say that. Grand theft of vehicle. And those are the only ones that I see aside from the two charges that are here. The reason that we are asking for an elevated bond of $10,000 on the first count is due to the fact that it is accompanied with a criminal mischief and the other prior arrest.
Counsel.
I'm sorry, I could not hear that last part, Judge. I apologize.
Yes, I was stating that we had not listed any priors. At this point, we did list prior arrests that he had for vehicle grand theft, as well as fraud and false ID given to a law enforcement officer. We are asking for an elevated bond of $10,000 on the first count, and on the second count, a standard bond.
Okay.
Judge, it's my understanding that those charges were dismissed, and there's no reason for an elevated bond in this case. Mr. Grady is a 21-year-old individual. There's no indication that he's violent or has any violent tendencies or is a danger to the community. In addition, Judge, he is from out of state. He has an out-of-state address, which again poses the bondman issue where it's going to be difficult for him to find a bondsman. So if the court increases the bond, then he'll be in a position where he has to pay even more straight out of pocket without the assistance of a bondsman. If the court granted standard bond in this case rather than a elevated bond, that would still pose the same issue. So the defense is requesting that the court grant a reduced bond so that he can post the totality of that without a bondsman, because he won't be able to get a bondsman, and the amount of $500 on count one and $250 on count two.
Thank you. As to count one, bond is set at $7,500, count two, $2,500. Thank you. Next case, René Ariel Luis Escuela, F255865. Mr. Luis Escuela.
He's present before the court, Judge. He does require a Spanish interpreter.
The services of the Spanish interpreter. Where do we have the interpreter? I think he's coming on now.
Ready?
Mr. Interpreter, thank you for helping us. Mr. Luis Escuela, good morning. You're here today because you're charged with 1 count of aggravated battery with a deadly weapon, 2nd-degree felony.
Buenos días, buenas tardes, señor Luis. La escuela se encuentra aquí el día de hoy porque se le imputa un cargo de agresión física calificada con arma mortífera, un delito grave.
At this time, the court finds that there's probable cause in this case. Your attorney is there to represent you. Sir, I'm issuing a stay away order in favor of Miguel Zuniga. You have to stay at least 500 feet away from this person, their home, their school, and place of employment. All contact is prohibited directly, indirectly, in person, through telephone, social media, and electronic contact. Please let me know if you understand that.
En este momento se ha determinado que existe motivo fundado para justificar este cargo y además se va a dictar orden de alejamiento con la presunta víctima que se llama Miguel Zúñiga. Le queda prohibido comunicarse con dicha persona de manera alguna. Igual le queda prohibido acercarse a menos de 500 pies de esa persona. Le queda prohibido comunicarse con él de manera alguna, que sea de manera directa, indirecta, en persona, por escrito, a través de terceras personas, por teléfono o en las redes sociales. ¿Quedó claro, señor?
You have to answer out
Hable
loud.
hacia el micrófono.
Yes.
Okay, thank you. State.
Yes, Your Honor, state would request standard bond. Given
What's the amount for standard bond in this case?
$5,000.
75, Judge, we have the wrong one written down. 75.
No objection to standard bond, Judge.
Okay, all right. It's gonna be $7,500 plus a GPS level 2.
La fianza será de 7,500 más monitoreo GPS nivel 2.
And Your Honor, just as it relates to the house arrest condition, I mean, Mr. Luis Escuela has never been arrested. He has no local priors. He has no prior contact with the criminal justice system. I think the standard bond of $7,500 is more than sufficient, Judge.
Okay.
Y señoría, en cuanto a la petición de detención domiciliaria, el señor no tiene antecedentes, nunca le han detenido, no tiene ningún contacto con el sistema de justicia previamente. Nos parece más que suficiente la fianza de 7,500.
All right, thank you, counsel. Your argument is noted. At this time, next case will be Ellie Nortelis, F25-5870.
Your Honor, Mr. Nutella says an AC, no bond.
Is that an F24-22269 or another case?
No, that's the case, Your Honor.
Oh, I'm sorry?
Yes, that's the case.
Okay, all right. So he's being held on F24-22269?
Yes.
Okay, thank you. Thank you so much. All right, Mr. Nortelis, good afternoon, sir. You're charged with 1 count of possession of cocaine, suspected cocaine for 3rd-degree felony, 1 count of drug paraphernalia with intent to use, 1st-degree misdemeanor, 1 count of indecent exposure, 1st-degree misdemeanor, 1 count of assisting officer without violence to his person, 1st-degree misdemeanor. Sir, at this time, the court has read the A form. The court finds there's probable cause. Your attorney is there to represent you. Let's go over the bond for your case. State, go ahead.
Thank you. Judge, the state would stipulate the standard bond except on the indecent exposure simply based on the fact that this was near us. It was on a school based on the allegations in the arrest form, Judge, where there are minors.
Okay, so what is your suggestion with respect to the 3rd count, you said?
1 moment, Judge. We would ask for an elevated bond on the indecent exposure. 1 moment to look up the standard bond. The standard bond for indecent exposure, as we have written it, Judge, is $1,000. But what we would be asking for, Judge, would be a $5,000 bond, given that there are minors.
Counsel?
Yes, Judge, I think the allegations in this arrest affidavit would seem to indicate that Mr. Nutella is homeless, or at least between locations.
You have to speak up. I lost you there.
Yes, Judge, I think the allegations in this arrest affidavit would indicate that Mr. Nutella is homeless, or at least between homes, and doesn't have a stable place to live. Judge, an elevated bond or the standard bond would have no difference because Mr. Nutella cannot post bond on either due to his financial situation, and he's already being held no bond, Judge. Standard bond is more than sufficient.
At this time, The court will set bond as follows: count 1, 2,500, count 2, 500, count 3, 1,000, count 4, 500. I'm sorry? Thank you, thank you.
Your Honor, I'm sorry, what was count 3?
1,000.
Thank you.
Thank you. Okay, next case, Joel Rodriguez. Joel Rodriguez.
Present before the court, Judge.
Okay, Mr. Rodriguez, good morning or good afternoon, rather. You're charged with 1 count of burglary with assault or battery, first-degree felony, 1 count of battery, first-degree misdemeanor. And that's on F-25-5876. You also have F-25-5873, where you're charged with 1 count of aggravated battery with a deadly weapon or attempt, stalking, aggravated third-degree felony, and criminal mischief third-degree felony. And give me a minute to read everything. I have received counsel a motion for pretrial detention on F-25-5876.
Yes, Judge, and I would like to be heard on probable cause for the second case for the counts of aggravated stalking and criminal mischief.
Okay, we're gonna go there in a minute. Let's start with F-25-5876. Just give me 1 minute, please. The defendant refused. And then back in the court. And I push the victim, call police, and then get the scene. Defendant is booked. All related charges. Okay. All right, so at this time, the court finds probable cause in F-25-5876. Your attorney is there to represent you. Mr. Rodriguez, I am issuing a stay away order in favor of the alleged victim, initials GP and initials EG. 2 different victims. You're to stay away from these individuals at least 500 feet away from them, their home, their place of employment, and school at all times. All contact is prohibited. Electronic contact via phone, third person, third parties, directly or indirectly. Do you understand that?
Yes, ma'am.
All right, thank you. It's been answered. Now, let's proceed with respect to bond in this case.
Judge, I would like to be heard on probable cause in the second case.
In the second one, you will.
Oh, okay, understood, Judge. You're taking them one
I'm
at a
only
time.
going 1 at a time. That's how I can do it. I don't do these cases every day, so I need to go 1 by 1. Had it been, they would have been misdemeanors. I could do them all at the same time. Go ahead, counsel.
Your Honor, as to case F-25-5876, the state has filed a motion for pretrial detention. It is the charge of burglary with an assault or battery. That is a violent or a dangerous crime as listed in the statute that we've been referring to today, and as listed in our motion. We would argue that the defendant poses a danger to the community, not only because that this charge falls under that statute, but also because he has another open case in front of you right now with an aggravated battery. He does have prior convictions, including a guilty conviction where he for heroin trafficking, as well as hallucinogenics. The state would ask that you grant a motion for pretrial detention.
Counsel will hear from you.
And I'm sorry, Judge, I was speaking with Mr. Rodriguez, but it's my understanding they filed a motion for pretrial detention, and we're just simply arguing the basis of that. Is that correct?
Yes.
Okay, so Judge, I received some additional information and I would now like to be heard on probable cause in count 1 or for case 1, and I would like to request a probable cause hearing. It's my understanding that Mr. Rodriguez's name is actually on the lease of that house, and you can't burglarize a house with your name being on the lease because you have a right to be there. So there would be no probable cause for burglary in that situation. So the defense is requesting a probable cause hearing in case 1.
And ending in 876?
Correct, Judge.
I didn't read any of that on the A form. I heard he began knocking on the victim's apartment.
Yes, Judge, but that's
court to be open, so.
They were,
He's
they're,
there, you said?
I'm sorry, Judge?
You said he leases that apartment, the lease is under his name, and he doesn't have keys to the apartment? Is that how it is?
Mr. Rodriguez and the female alleged victim in this case are still technically married, but they're separated. They resided together in that house and they have a lease on that house, and Mr. Rodriguez's name is on the lease as well as his wife's name is on the lease. So Mr. Rodriguez, if his name is still on the lease, and that's why we're requesting a probable cause hearing to hear from the alleged victim.
Okay.
But if his name is on that lease, you can't burglarize a place you have a right to be.
I understand. I just was reading and saying that he was knocking on the door, so. And I didn't read anything about a lease, but if you want a probable cause hearing, we can reset for tomorrow.
No, there's a mistake.
Okay, no objection from the state. So at this time, we'll go ahead and
Just so you're aware.
I'll vacate, yeah.
We'll just set both cases for public. Cases have to stay there.
Thank you. Thank you. Okay, so we'll have.
Your Honor, we're restating both cases for PCH, correct?
Yes, we'll have a PC hearing tomorrow, March 23rd. So this will be on for tomorrow. And on the second case as well, PC hearing, March 23rd. Okay, thank you.
Thank you.
We're nearing 1:30. At 1:30, I'm gonna have to take a break to go to the other courtroom. Next case, Scott, let's see how much we can move along. Carlos Quesada Rodriguez.
That's not the one, Judge, excuse me. It's on his phone. Yeah.
Mr. Quesada Rodriguez is present, Judge. He does require the services of a Spanish interpreter.
The services of the interpreter, F-25-5874. The services of the interpreter, please, if you can come on for us. Thank you, appreciate it. Can I have a no drive order, please? Thank you. All right, sir, good morning. You're here today because you're charged with driving while license suspended, third of subsequent conviction. It's a third-degree felony.
Buenos días, señor. Se encuentra aquí porque se le acusa de manejar con la licencia suspendida después de tener 3 condenas previas por lo mismo o más, un delito grave de tercer grado.
I find there's probable cause. I'm issuing a no drive order. You cannot drive in the state of Florida until you have a valid driver's license, sir. Do you understand that?
Se dicta una orden que le prohíbe conducir hasta que obtenga una licencia. Señor, le queda prohibido volver a conducir hasta que saque una licencia vigente en la Florida. ¿Quedó claro, señor?
Let me know if you understood that.
¿Ha entendido, señor?
Please answer the question. Did you understand that?
I'm sorry, Judge, could you repeat that? Mr. Quesada Rodriguez is trying to speak with me about something.
Okay, sir, I'm speaking right now. It's my turn now. I'm gonna ask you to please cooperate with the court. I'm issuing a no drive order. You need to understand you cannot drive in the state of Florida until you have a valid driver's license. Please let me know if you understand that.
Señor, le pido que colabore con la jueza. La orden que acabo de dictar le prohíbe conducir en el estado de la Florida hasta que obtenga una licencia vigente. ¿Ha entendido, señor?
Sí, lo que no lo quería decir.
No hablo.
You don't have to say anything, sir. Bond is set, count one, $2,500. Counsel, I am the associate administrative judge for traffic. He can call my office if he needs any assistance in getting a good license. Please let him know that he can call my office. We're more than happy to help him, okay?
Understood, Judge.
Your Honor.
Would the court consider granting pretrial services, being that it's a DWLS charge and he has no priors in the last 10 years based on what I'm seeing?
Is he qualified? Any objections, State? Pretrial services, alternate bond, $2,500.
Judge, given the severity of the priors, we would object. He has he's a convicted felon, Judge.
Okay, counsel, I reconsider and respectfully deny. $2,500 is the bond. Thank you. Yaciel Lazo Meneses, F-25-5880.
2,500 de fianza.
That's a bond out, Your Honor.
Thank you so much. Next, Alain Soler Moreno.
Yes, Judge, he's present.
Good morning, Mr. Moreno. You're charged with 1 count of robbery, strong arm robbery, second-degree felony. I am reading the A form. Your attorney is standing next to you. Forcibly remote the victim's number.
Is this an add-on?
The victim.
So these one.
Forcibly remote the victim.
Come back here, please.
No, same part.
We got it. Thank you.
Counsel, do you have any arguments?
For probable cause, Judge?
Yes.
Not,
Or finds probable cause, your attorney is appointed, sir. State, it says to reset. What is your position? And then I'll hear from counsel.
I'm sorry, you said it says to reset?
To be set, to be set, to be
Oh,
set.
yeah. Your Honor, the state requests $5,000 bond.
Counsel?
yes, Judge, Mr. Moreno has no prior arrests, no prior involvement with the criminal justice system whatsoever that I'm seeing. He's 21 years old, Judge. The defense would request that, Your Honor, order him into pretrial services.
And in this case, are we issuing a stay away order?
Yes, Your Honor. Pulling it up.
Can I please have it so I can explain it to him?
Yes, Your Honor.
Do you have
What is the alleged victim's name? And I'll start letting him know. I didn't see it on here.
Sandra Moreno.
Okay, Mr. Moreno, I'm issuing a stay away order. You have to stay at least 500 feet away from Sandra Moreno. That means her home, her school, her place of employment, and her person at all times. You're to have no contact with her. All contact is prohibited directly, indirectly, in person, through third parties, telephone, social media. Do you understand that?
Yes, ma'am.
All right, and stay away order has been issued with respect to bond. Counsel, you said something with respect to bond. I'm sorry.
Yes, Judge, defense is requesting pretrial services. Mr. Moreno has no priors. He has no prior arrests based on what I have. It's also my understanding that the aunt has been removed from the house. So she's no longer going to be staying there. There's a stay away order in place. Mr. Moreno is going to continue to reside with his mother away from his aunt. And being that he has absolutely no priors, Judge, I think pretrial services would be appropriate in this case.
Counsel for the state. And alternate bond would be what in your recommendation, counsel?
Pretrial services with an alternate bond of $2,500 or whatever standard bond is, pretrial services, alternate standard bond.
Does he qualify for pretrial services? You don't take? Oh, they don't take that charge, counsel.
Well, it's my understanding the court could order him in, and you know, based on these allegations, the allegation is that there was a taking of a phone from an aunt, Judge. So I don't think this is necessarily the type of strong arm robbery that would, you know,
I understand.
a reason for the exclusion, Judge. So if the court could order him into pretrial services,
Right.
he can be released.
Yes, I could. Any objection to pretrial services, alternate bond?
Your Honor, if you were to order him, then his pretrial services, we'd ask that the ultimate bond be set at $7,500.
Okay, that's fine. Counsel, your request is granted with respect to pretrial services, alternate bond, $7,500. Okay, so pretrial services, alternate bond, $7,500. I am hearing they're ready for me in the other courtroom, so I'm gonna go there and try to run back as fast as I possibly can. And I will be back with Mr. Jonas, but just give me a couple minutes and I'll be back, okay? Thank you, everyone. Off record for now.
Thank you, Judge.
Yeah. Hopefully when we get back, how many cases? This one case? Shouldn't take too long. And hopefully we'll get back and won't take too long. Yeah. Okay. That's fine.
That's the one she just did.
Yes.
Okay, go. Thanks for bearing with us. It's my first time doing some bonds.
Oh, no, I. went and they would send like one person. to the bar and- Thanks.
Let's go on record. Good afternoon again. Thank you for your patience. Next case is Mr. Jarvin Jonas,
Yes, Judge, he's present before the court and I would like to be heard on probable cause.
F-25-5889. Mr. Jonas, you're charged with one count of defrauding the innkeeper, $1,000 or more, third-degree felony, and resisting an officer without violence to his person, first-degree misdemeanor, I'm so sorry. And let me read the A form first. Give me 1 second, counsel, and I'll tell you when you may argue. Go listen, Dave.
Judge, corrections is asking to be let into the Zoom room. I guess they're not in.
Oh, who's handling the Zoom? Maybe video might be? Thank you. Please let corrections in. Thank you. Bring 2 minutes of flag. Looks like she's a push. Poetic eastbound. Matching.
Your corrections, can you hear us?
Yes, I can. Thank you. We're on the
Thank
case
you.
of Mr. Jarvin Jonas.
Judge, he's present
What is
before-
your argument, counsel? Go ahead.
So, Judge, he was arrested for defrauding an innkeeper. If you look to the second page, the second paragraph from the bottom,
Okay.
It indicates that there was a credit card on file for this booking, and that the credit card on file was initially declined, but then he was able to call the credit card company and get the payment approved. So the payment went through. So I don't think he can be charged, or I don't believe there's probable cause for defrauding an innkeeper where there's a card on file and that card has been approved for payment and could have been used for payment. That's the only allegation in this arrest affidavit about any payment or any payment means or any attempt to make payment. So if you put your card down at a hotel and it works, I'm not sure how there can be probable cause for defrauding an innkeeper in this case, Judge. There is probable cause for count 2, resisting an officer without violence, based on the A form because they ran. But if there's a working card on file, there's no probable cause for defrauding an innkeeper.
Hey, do you see that? Says the card was on file. The card on file initially declined. Contacted a third-party company, was able to get the card to go through.
Yes, Judge, and what you see on the last form, we do believe the state's position, given the fact that the defendant was in, it does provide support and consciousness of guilt, shown that the defendant was staying on foot and the officer continued to run away. We would like a little bit more clarification, and we might have the officers come in if we were.
Okay. Yeah, let's reset it for PC.
Judge, and this is a co-defendant case, Judge. Mr. Jonas and his co-defendant, Mr. Mickle, are 23 years old. They're college students from New Jersey who are here on vacation. They need to be able to get back to their home. They need to be able to go.
Counsel, but you're making arguments, and just like I gave you an opportunity to a PC hearing on one case, in this case, I find that it is appropriate that if they want a PC hearing, I'll grant them and we'll hear it tomorrow.
I will withdraw my motion for probable cause determination, and I will stipulate to probable cause if the court were inclined to grant a bond in the amount of $1,000 on count 1 and $500 on count 2.
Okay, so PC argument withdrawn. Any objection to $1,000 each count?
No, Judge, the defense is requesting 1,000 on count one and 500 on count
Oh,
two.
well, 500 on count two is a standard. Sir, I'm issuing a stay away order. Mr. Jonas in favor of Lowe's Hotel, 1601 Collins Avenue, Miami Beach, Florida. You have to stay 500 feet away from that location. You understand that? I'm sorry, you gotta speak up.
Yes.
Thank you. If you violate the court order, you can face jail. If you're found guilty, the PC hearing is withdrawn. Any objection? $1,000 count one, 500 count two. Thank you.
And Judge, Mr. Jonas does still have property at the hotel. Would Your Honor permit him to go back to the hotel with the a police officer to get the property?
A one-time only. Let me have an order, please. We'll allow him to go. So there's a stay away order in effect. And one time only where the police officer may retrieve his documents. I'll write it in the stay away order. Okay, let me include it in there. Thank you. So, counsel, I will include here, defendant allowed one time with a police officer to return to hotel to retrieve personal belongings within 48 hours from this order. Thank you, counsel. Your request is granted.
Thank you, Judge.
All right. Next case. Puji Lexus Mickle.
Yes, Judge, he's present before the court, and this is the co-defendant to the previous case. So the defense would have made the same probable cause arguments, but again, we'd be willing to waive those probable cause arguments in exchange for a bond of $1,000 on count one, 500 on count two, and then a $1 bond on count three. Okay,
Any objections, State? Let me have a stay away order as well. Mr. Mickle, you're here today because you're charged with defrauding the innkeeper $1,000 or more, third-degree felony, resisting an officer without violence, first-degree misdemeanor, and cannabis possession, first-degree misdemeanor. At this time, your attorney has waived the PC arguments. That will be noted as to count one, $1,000, 500, count two, $1, count three, sir. In addition to that, I'm issuing a stay away order. You have to stay away from the Lowe's Hotel in Miami, the city of Miami Beach, that's located at 1601 Collins Avenue. You fail to abide by the court order, you can face jail. You understand that?
Yes.
Okay.
And Judge, will he also be permitted to go back one time with?
But counsel has waived the arguments. I'm sorry, counsel, go ahead.
I'm not sure if the court mentioned it. We are having trouble hearing, but is the court going to permit Mr. Mickle also to go to the hotel one time with police officers to retrieve
Yes,
his property?
I'm gonna note it here in the stay away order. Defendant allowed to return one time only to hotel with police officer, not by yourself, not with a friend, with police officer to retrieve his belongings within 48 hours from date of this order. I don't know how you cannot hear me because I feel like I'm screaming.
It's not the volume, Judge. It's just cutting in and out every once in a while.
Oh, okay, because I feel like I'm screaming and
You're good to go.
almost feel bad actually. Devin Calhoun.
Your Honor, Mr. Calhoun, this is an added charge.
I see that. Thank you. All right, Mr. Calhoun, you're here today because you're charged with a robbery with an armed weapon, first-degree misdemeanor, one count of battery, first-degree misdemeanor, one count of disorderly conduct in an establishment, second-degree misdemeanor.
Judge, I would like to be heard on probable causes to count one.
Go ahead.
So Judge, he's charged with, or he was arrested for armed robbery with a weapon. There's no indication that the arrest affidavit that Mr. Calhoun actually had a weapon. The only allegation is that he put his hand underneath his shirt and said, "I will shoot you." There's no allegation that a weapon was seen by the alleged victim. There's no allegation that a weapon was found on Mr. Calhoun. And for that specific charge, armed robbery with a weapon, there has to be actual possession of a weapon. Putting your hand in your shirt and saying, "I'll shoot you," is not sufficient probable cause to say that there actually was possession with the weapon, Judge.
Steve?
Yes, Judge, because we only have to prove probable cause and not beyond a reasonable doubt, the fact that the defendant did make a threat that he had a firearm, we do believe that is sufficient in this case for the officer to make an arrest.
Sufficient for the officer to make an arrest for a crime of strong arm robbery, but not for armed robbery, which requires actual possession of a weapon, Judge. There's that in and of itself is not probable cause that Mr. Calhoun actually possessed a weapon, which is required.
Okay.
Yes, Judge, and while that might be an argument for beyond a reasonable doubt that the defendant did have a weapon in his possession, the fact that the defendant made statements as to the fact that he was going to shoot the victim, we do believe that's sufficient probable cause in this case.
I'm gonna find probable cause based on the affidavit. Public Defender's Office is appointed. Sir, I'm issuing a stay away order. You have to stay away at least 500 feet from Advanced Auto Parts located at 12400 Northwest 27th Avenue in Apalaca, Florida. And you also have to stay away from Ernesto. What does it say here?
The victim's name, Judge, is Ernesto Molinet Ferreras.
Ernesto Molinet Ferreras and Angel Laredo. You have to stay at least 500 feet away from them, their home, their school, their place of employment at all times. All contact is prohibited by phone, in person, directly, through third parties, indirectly, and electronic contact. Do you understand that, Mr. Calhoun?
Yes.
Thank you. And with respect to bonds, I'm receiving here a motion for pretrial detention for him. Go ahead.
Yes, Judge, given the fact that the defendant was arrested for carrying an armed weapon to commit a robbery, in addition, there was a double battery in this case where the victim sustained lacerations, but we are moving for it on the first count, not only because of what's alleged, but additionally because the defendant does have prior convictions for felon in possession of a weapon, other convictions. I'm not sure what this is, a felony 3 CCFBEF. Grand theft of a vehicle, petty theft, and more counts, Judge, so I can continue on if you would like.
Counts.
Defense objects to the pretrial detention motion, Judge. We don't believe that's sufficient to show that he's a danger to the community. We request a bond of $7,500 on count 1 and standard bond on the remaining counts.
You're still asking for a pretrial detention?
Yes, Judge, we will still be asking for. He does have 3 counts of grand theft of a vehicle, Judge, felony. He's found guilty.
So at this time, with respect to the case of Mr. Calhoun, F-255872, defense's objections noted for the record. The motion for pretrial detention is hereby granted. The order is entered and the motion is granted based on the grounds indicated in the order. Count 1, no bond. Count 2, $1,000. Count 3, $150. Thank you. He's got.
You are in
battery has 2 counts. I'm sorry. Count 3 will be $1,000. 150, count 4. So count 1, no bond. Count 2 and 3, 1,000 each. Count 4, 150. Thank you. Next case is Miguel Blanco. Mr. Blanco.
Present before the court, Judge.
All right, Mr. Blanco, you're here today because you're charged with battery on a person 65 years of age or older. It's a 3rd-degree felony, and the court has read the form. There's probable cause in this case. I'm issuing a stay away order, sir, in favor of Gladys Blanco. You're to stay away from Gladys Blanco at least 500 feet away from her home, her place of employment, and school at all times. All electronic contact is prohibited, directly, indirectly, social media, internet, in person. All contact is prohibited. Do you understand that, Mr. Blanco? Do you understand the stay away order that I just read to you?
Oh, yeah.
Okay, thank you.
Judge, he does have property there, so he would need the opportunity to go and pick up his property with the officer.
Okay, state any objection to that?
To him, his property as long as he's an officer. No.
Okay, defendant shall be allowed 1 time to return to property with a police officer to retrieve, and that includes medication, your tools, and your clothing, and your personal papers. It's not to go back and say, the bedroom is mine and this is yours. That would have to be in a court of law. It is the basics. I don't have space in the order to put that, but I want to make sure you understand that it's your work tools, your medication, your passport and personal papers, and your clothing. If you say that the bedroom set is yours, you have to go to court for that. You understand, sir? Please let me know if you understand.
Well, I definitely understand everything.
Okay, thank you. I
does-
just want to make sure, because a record is not picking it up unless you actually say it on the record and articulate it.
He does also have a vehicle there that belongs to him. The court's not going to preclude him from having his vehicle, correct?
If it's in his name, that's fine. If it's a joint name, he's got to go to court.
Understood, Judge.
Okay, so if the registration is registered to his name, it's titled in his name, he can retrieve it, okay? To retrieve his personal belongings within 48 hours, only with a police officer from date of this order. And I'm going to define as medication. I'll write it in here. Clothing, tools, and personal papers that belong to you. What vehicle is it? What is the make and model of the vehicle, please?
It's a Toyota Camry, 2011.
2011
Yeah.
Toyota Camry,
Yeah.
only if registered
Yes.
in defendant's name with a valid registration.
Definitely.
Okay,
Definitely.
thank you.
Okay.
So, and state with respect to bond in this case.
Judge, we would be asking for an elevated bond, given that the defendant was arrested for the same charge in 2023, even though it was not continued upon, given the nature of the relationship to what happened elevated.
I'm
Okay,
sorry.
counsel, let's hear from you.
Yeah, I wasn't able to hear what the state said. What's the basis of their elevated bond request?
Yes, counsel, what I stated was that although the previous case from 2023, battery on an elderly 65 or older, was no pros, we would be requesting an elevated bond, given that it appears that this is the second, if not more times, that this situation could have occurred, and given the nature of the relationship, we are asking for an elevated bond.
I don't see a 2023 arrest for that. Was that local or?
Let me tell you where it was from. Aventura, nope,
It's Miami-Dade County.
Miami-Dade County Sheriff's Office, November 16, 2023 was the date of the arrest.
I don't have that on my priors. I don't know if there's some
Why?
confusion.
This is a national, these are from the national priors, Judge. This might have gotten sealed, maybe?
Oh, okay, because I don't have it, but if it's sealed, it's not a conviction.
No, Judge, and it's not a conviction. The
Oh,
state is just
okay.
simply asking the court to take it into account.
Oh, okay,
And
because
Judge, I'm
I
sorry.
don't mind either. Go ahead.
I don't have that information here, Judge. I mean, I know that sometimes there's issues with NCICs where it returns priors on aliases on different people who share a similar name. Miguel Blanco. is
Recommendation of bond, counsel?
Defense is requesting that the court issue bond in the amount of no monetary bond with pretrial services. If the court is not inclined to order Mr. Blanco into pretrial services, the defense would request that the court grant bond in the amount of $2,500. He has no prior convictions based on what I have, and I understand the state's representations with the 2023 arrest, but based on what I have, he hasn't been arrested in over 20 years, Judge. So I don't think an elevated bond is warranted in this case, and I think he should be released on a reasonable condition that he can afford, and pretrial services would make it, make him be released without having to pay any money, and he could probably afford $2,500 if the court's inclined to deny the request for pretrial services.
Judge, just to make the court aware, this defendant was arrested in 2004 and 2006 for driving under the influence. I don't know what the disposition of those cases are, though, so I cannot represent that. And there was a domestic violence assault municipal ordinance.
I reviewed the priors. Counsel, I'm going to grant your request and set bond at $2,500, but I'm going to plus GPS level 2. Thank you. Next, we have the case of Lawrence. Last one. Yes. No, it's not our last one. Anthony Morris, F25-5862. Mr. Morris, good morning. You're charged with burglary with assault or battery, first degree felony. Okay, the court finds there's probable cause in this case. And your attorney is there to represent you, sir. I'm issuing a stay away order in favor of Takira Coley, Takira Coley. You're to stay away from this person, at least 500 feet away from them, their home, their place of employment and school at all times, and from the address at 790 Northwest 95th Street, apartment 104 in Miami. Do you understand that, sir?
Yes.
All contact is prohibited, and that includes electronic contact by telephone, third parties, in person, directly or indirectly. Do you understand that all contact is prohibited?
Yeah.
Thank you. State.
Yes, Judge, if we could just briefly try to see, there's two battery cases previously that I see. One of them was an aggravated battery that was a withhold from 2016. Judge, we just want to see and make sure that it's not with the same victim. But in this case, the defendant does have very lengthy prior convictions for felonies as well as misdemeanors, Judge, and resisting officers. We do not see that it's the same victim, Judge, for the battery case, but given that he has a prior battery, we're asking for an elevator.
Okay, all right. Counsel.
The state requested what? I didn't hear the last part.
Sorry, Judge, we actually gave you an order for pretrial detention. Yes, they filed a motion for pretrial detention, counsel, in this case.
The defense objects to the motion for pretrial detention, Judge. Right. Yeah, give me 1 second, Judge, to speak. And so, Judge, I had the opportunity to speak with Mr. Morris, but the defense objects to the pretrial detention motion. This charge does fall under the definition of dangerous crimes, but there's not sufficient evidence to show that he's a danger to community. The state mentioned some of his priors, but all of those priors are nearly 10 years old, over a decade. I don't even believe that he's been arrested in the last decade, Judge, so I don't believe there's sufficient showing to show that he is a danger to the community or a flight risk in any way. So the defense would request that the court exercise its discretion and grant bond in the amount of $7,500.
All right.
We would still be asking for the pretrial detention.
At this time, the motion for pretrial detention is hereby granted. The order is entered. The order, the motion's granted on the grounds indicated in the order, and count one, no bond. You will see another judge, sir, no later than Monday, should be. Next case, Nicholas Kevin Maximin. Mr. Maximin, good afternoon, sir. You're here today because you're charged with 1 count of strong arm robbery, 2nd-degree felony, 1 count of tampering with a witness or victim, 3rd-degree felony, and 1 count of battery, 1st-degree misdemeanor. Just give me 1 second. At this time, the court finds that there's probable cause in this case, sir. Your attorney is there to represent you, and I'm issuing a stay away order, Mr. Maximin. You have to stay away from, I know we're writing fast, but is it Janilka? Or Janilka Simon? You have to stay 500 feet away from Janilka Simon, her home or school, her place of employment at all times. All contact is prohibited, including electronic contact, and in person and through third parties. You have to stay away 500 feet at all times from 21113 Northwest 14th Place, number 630 in Miami Gardens, Florida, 33169. Please let me know if you understand that.
Yes.
Okay, failure to abide by court order can result in jail, and that's okay. All right. Now, with respect to bond state.
Yes, Your Honor, the state would be requesting standard bond. He does not have any prior convictions. However, he has previously completed PT for resisting violence. He also has been arrested for
bond in this case. The defendant only in 2024 has been arrested 12 times. He had 6 convictions in 2024. Burglaries, felony burglaries, multiple of them, felony grand theft, 3rd degree, burglary, occupied vehicle, tools for burglary, as well as petty theft conviction. Judge,
I'll hear,
that's only in 2024.
I'll hear from the defense.
So Judge, he's already being held no bond and he's homeless, so he probably couldn't afford any monetary bond in the first place. The defense would have no issue with standard bond in this case, but an elevated bond would be meaningless.
Standard bond is issued $2,500, count 1, which is the only count in this case. Thank you. Next case, we have Jorge Luis Ruiz Alfonso, F25-5857.
Mr. Ruiz Alfonso, Your Honor, is the valid felony offender of special concern.
Okay, thank you. F24-520, he's out of probation on that case, and he'll be held on F24-520, so there's no hold, correction.
He requires the services of a Spanish interpreter.
Okay, the interpreter is present. Mr. Interpreter, can somebody let him in? Is that what it is? Why he has his? Okay, thank you. All right. Good afternoon, Mr. Jorge Luis Ruiz Alfonso.
Buenas tardes, señor Jorge Luis Ruiz Alfonso.
Yeah, buenas tardes.
Good afternoon.
Corrections advised the court that you're categorized as a violent felony offender.
Los agentes penitenciarios me han informado de que usted ha sido clasificado como reincidente violento.
Ofensas violentas.
What was that? Violent felony offender?
Offender,
Reincidente violento.
Okay, sir, in addition to that, I indicated to probation that on F24-520, you're out on probation and you will be held to see the division judge in Division 13.
Y además les indiqué que en el caso F24-5520 usted estaba cumpliendo un régimen de libertad vigilada y por lo tanto se le va a retener hasta que comparezca ante el juez en la división 13.
And Your Honor, in the interest of efficiency, the defense would have no objection to standard bond, being that he's already held.
Okay, all right, 2,500 count 1, 2,500 count 2, and court finds there's probable cause. And sir, you are charged with 1 count of petty theft, 3rd degree felony, 1 count of assisting officer without violence, 1st degree misdemeanor.
Judge, and because the corrections did inform us that he is a violent felony offender, that he is not eligible for bond of any type, or any other relief, and the court should place a felony hold, which I believe that you did. But you did place a felony hold?
Yes, I did.
Okay, excuse me, Judge, then that's what I just figured.
And Mr. Ruiz Alfonso, I'm issuing a stay away order, let's run it up there, from the Walgreens located at 7910 Northwest 27th Avenue. They have to stay at least 500 feet away from the Walgreens in Miami, 7910 Northwest 27th Avenue. If you have a court order, you can face jail if you're found guilty. Please let me know if you understand that.
Señor, se le acusa de hurto de menor cuantía, un delito grave de 3er grado, además de desobediencia a la autoridad, un delito menor de 1er grado, y ya que le han clasificado como reincidente violento, no le queda la posibilidad de salir bajo fianza y además...
Okay.
Además, le queda prohibido acercarse de nuevo mediante orden judicial al Walgreens ubicado en el 7910 northwest de la avenida 27 en Miami. Si incumple la orden, terminará de nuevo en la cárcel. ¿Quedó claro?
Understand that?
¿Entendido?
Sí.
Yes.
Thank you, sir.
No, you're gonna be able.
Okay. Next is Wilfredo Antuna, F25-5839 counsel. For the Public Defender's Office, Mr. Antuna refused yesterday, and I have information that he refused today, or he's here.
He's present, Judge.
Present, okay, thank you. So, Mr. Antuna, good afternoon. You're here today because you're charged with robbery, home invasion. It says with a firearm, first-degree felony, kidnapping, first-degree felony, robbery, home invasion, armed conspiracy, second-degree felony, robbery, armed weapon with a mask, first-degree felony, and each is 1 count. Give me a moment to read the A form. Sir, at this time, the court finds that there's probable cause in this case. Your attorney is here to represent you. I am issuing a stay-away order in favor of the alleged victim with the initials YV. And you have to stay at least 500 feet away from that person, their home, their school, and place of employment at all times. All contact, including in person, through third parties, telephone, social media, and electronic contact is prohibited. Do you understand that, sir?
Yes.
Do you also understand you have to stay at least 500 feet away from 13037 Southwest 284th Street in Miami? Do you understand that?
Yes.
Failure to abide by the court order can result in jail if you're found guilty. I have received a motion for pretrial detention. And there's more victims in this case, and supposedly more alleged victims, allegedly. Mr. Antuna, you have to stay away from initials YV, YS, AV, and YC. The stay away order that I just explained to you applies to all those alleged victims. Do you understand that?
Yes.
Okay. Failure to abide by the court order can result in jail. With respect to the pretrial detention motion, counsel for the defense or state?
Yes, Your Honor. The defendant here is charged with several violent crimes, including robbery, kidnapping, and robbery, armed robbery with the mask and a home invasion. These are dangerous crimes. The state's position is that the defendant poses a danger to the community, and we ask to hold him no bond.
On all counts?
On all counts, Your Honor. Additionally, there are one of the alleged victims is a minor. And I just wanted to bring that to the court's attention.
Let me hear from the defense at this time.
The defense objects to the pretrial detention motion, Judge. While these are dangerous crimes under the definition in the statute, Mr. Antuna has no priors, and there's no indication that he's otherwise a danger to the community, Judge. Defense would be requesting standard bond.
Your Honor, he does have a prior resisting without violence from 2023 withhold.
And additionally, Judge, kidnapping is one of the offenses that is listed in the statute.
Yeah. At this time, the court will grant the motion for pretrial detention. Defense objection is noted for the record. The court signs an order and grants the motion for pretrial detention based on the grounds indicated in the order. It counts 1 through 4, no bond. Thank you. Held, no bond. We have concluded for today. Found it. I will be here tomorrow. I'll see everybody tomorrow. Is everyone here tomorrow?
Did you put a no bond on all 4 counts?
No bond, no 4 counts, yes.
Thank you.
Okay, thank you, Judge. You will have Alondra, Ibarra, and Juan Sarteno, and we will talk about the PC hearing for tomorrow.
Okay, all right, thank you. Thank you, everyone. I'll see you tomorrow. You hold your hand. Okay, all right. Not you? Okay, all right. Okay, all right, sounds good. Okay, sounds good. Thank you. I'll see you tomorrow. All right. Have a good one. Thank you.
Maybe not, but. How good you guys had today. This is a light calendar, and we were not here till 7 o'clock at night. I've been here about how many people they've heard.
No, why? Like, they can't schedule more people. You guys put out of the home, or you guys do the whole day?
We're doing
No, we just, so it's 7 in. That's because no one is arguing. We don't show them.
This is the main reason why. Yeah.
Yeah, we are.
No, we know how it is. They give you guys the stuff until you do it.
No, if you don't do it, it's like.
You know, we have to put it on the record. Obviously, it's nice that you guys told